Professional Engineers and Land Surveyors, and I'd like to call the special board meeting August 7, 2005. And in doing that, I'd like Mackenzie to please start your recording if you have not already.
We're all set.
And it appears by our roll, myself, Mr. Peden, correct? Mr. Blaisdell. Mr. Blaisdell?
I am here.
Thank you, sir. Ms. Warrett?
Here.
Mr. Ballard? Ms. Kramer?
Here.
Thank you, ma'am. Ms. Lagerberg? Not yet present. Mr. Harney?
Yeah, Doug, I'm here, but just note that my peripherals are not connected because WebEx stinks.
Thank you for at least the opinion. Okay. I see Ms. Jackson and Mr. Fuller, Mr. Dickinson.
Here.
Ms. Short.
Here.
And Mr. Garcia.
Here.
Thank you. And Ms. Lund.
Here.
And Mr. Rasmussen.
Here.
And Ms. Horton.
Yes.
Yes. Thank you. Thank you, ma'am. Greg Schiefstein.
Here.
I saw you at the table. Shannon, I believe I saw you at the table. And Mr. Shelley, is he present yet?
He's not online yet.
Okay, we'll keep an eye out for him. And it appears we have some guests. We'll identify if necessary soon enough. I'd like to call that order and the roll complete at this time and ask for a motion on the order of agenda.
So made. This is Aaron.
Thank you, Mr. Blaisdell.
Seconded. This is Marjorie.
Thank you, Miss Marjorie. Any comments, questions, changes? Hearing none, I'll request a vote on the order of the agenda. All in favor of the agenda as written, please say aye.
Aye.
Aye. Aye.
Any in opposition, please say nay. Any abstentions? Hearing none, accepting the order of the agenda as written. And next on our agenda item then is item 1.3 would be the approval of the June 17th, 2025 meeting minutes. I request a motion.
Marjorie,
to
I move
accept
to
the
approve.
minutes.
Sorry. I'll second.
Is that
Thanks, Marjorie.
Maureen and
That was
Marjorie, is
Maureen.
that as written?
Yes.
Thank you. Comments, questions, editorial amendments? Hearing none, I call the motion. All in favor of approving the 2025 June 17th meeting minutes as written, please say aye.
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 Were there any oppositions? Say nay. Abstentions? Hearing none, the minutes are approved as written. Next on our order of agenda then is our general public comment opportunity. All board meetings are open to the public and the board invites comments and discussions from the general public. Individuals may give verbal comments during the public comment period, with 3 minutes allotted to each speaker. You may comment about any matter that is on the agenda or any matter that concerns you. Board meetings are not adjudicative meetings nor hearings, so the board cannot accept and consider direct oral testimony in support of or opposition to any given complaint or application. Before you give any comments, please, we encourage you to familiarize yourself with the board's statutory authority. All public comments are subject to disclosure under the Public Records Act. I will ask and invite any public members for comment opportunity. I see a couple on our slate. We have one visitor that appears to be a Luke Lyman Grover. Do you have any comment, question at this time?
Good morning. My name is Luke Lyman Grover. I'm the president-elect of the Land Surveyors Association of Washington, and I'm just here as a guest at this time.
Well, welcome, Mr. Lyman Grover. We hope to get good involvement with the association. And I also see on the slate Mr. Zheng Wang. Mr. Wang, do you have any comment at this time?
Yes. Yeah, I do have a question to the board. Good morning, everyone. Yeah, thanks for the opportunity to speak today. As a homeowner, I appreciate the board's effort to uphold the professional conduct of licensed engineers and surveyors. Meanwhile, I'd like to raise 3 generic questions regarding a board decision regarding a complaint I filed. First is about identify a land surveyor. I understand the code requirement the surveyor to identify self before survey, and I just wonder if board share the same position that a licensed surveyor and his crew should present official identification or license information when requested by the property owner. The second question is regarding trespass, property under dispute. The question is, does the board consider lawful or professional for a surveyor to enter private property as a fenced property, especially when the homeowner has explicitly denied access? Should the surveyor's personal assumption about the property boundaries override a clear refusal of entry from owner? I also wonder if it's a fundamental requirement for a licensed, surveyor to understand and adhere to the laws and the professional code by the Washington. And if the surveyor, lacks knowledge of this, lack knowledge of relevant status and disregard them, does it raise serious question about their professional qualification and the fitness to hold a license? And if a matter, whether a matter category as civil fire or not, is it within the board's authority and the duty to investigate and, when appropriate, discipline surveyors who appear to have violated the Washington Code? In summary, I'm kind of concerned that right now the board's current approach, in my case, may prioritize the convenience of surveyors over the safety and the legal rights of homeowners. That's all I want to say here.
Thank you for your comment, sir. Your comment does appear to relate primarily to a personal complaint, and we do have jurisdiction over many matters, most matters associated with surveyors and all those under the aspect of professional land survey. We have issues of complaint management and advancement of such, and we have the opportunity also for you to submit questions, written questions for the board to answer in particular if those are not absolutely clear in code.
I believe I asked questions email before, but I don't get clear answer on my questions. And also, this question are generic questions. It's not pertaining to only my case. It's generic questions on, on the code of, guidance surveyor to do the survey, and also the board's role to investigate and discipline the.
Thank you, sir.
If
We
they are not following
welcome,
code.
we welcome your written queries to our board, and as you detail those queries, we'd be happy to respond to those.
Okay. Anyway, thank you for the opportunity to speak here. I will email the board my questions and concerns, and looking forward to reply. Thanks again.
Thank you, sir. Do we have any other public commenters, questions at this time? Do we have anyone else come in, Mackenzie? We have a Mr. Warren.
Yes,
Mr.
that is who
Warren,
has joined.
I'm sorry?
I was just saying that's the only one who's joined.
Okay, and we still don't have counsel yet? Okay. So, at this point, we will have a what's called an executive session pursuant to RCW 4230-110. That's that's RCW 4230-110. And for the purposes set forth therein, the board will move into executive session portion of the meeting to consult with counsel and to discuss matters related to enforcement in cases in current litigation. The executive session will last until 9:30. Once the executive session concludes, the board reconvenes open session. It is now 8:12, and the open session will reconvene at 9:30. Ms. McKenzie, where will you please pause recording, excuse our guests, and lock this meeting? Thank you.
All right, we are all set.
Thank you, Mackenzie. Welcome back to open session of the BRPELS special board meeting of August 7th, 2025. And we're going to advance on our agenda items. Section 2, disciplinary actions. 2.1 involves a board order and case deliberations from case managers. Please lead off with that for the board order, Jill.
Thank you, Mr. Chair. We have one proposed agreed order for the board to consider, and the case number is 2024-08-1939-00LSV. The respondent is Thomas N. Woldendorf, and he is a professional land surveyor. The facts of the case were that Mr. Woldendorf violated WAC 196-27A-020 in that he was not communicating with his client or being honest with his client. And there was also a violation of WAC 332-130-145 in relation to a topographical survey he performed. What we're proposing is a 1-year suspension, and that suspension would be stayed contingent on Mr. Woldendorf paying a $2,500 fine within 90 days.
Questions from board members regarding this order?
Would you like a motion?
We would. That's a good question.
I move that we approve the board order for signature by the chair.
I second
This is
that.
Aaron. I second. Go ahead, Maureen.
Sorry.
Okay, so now, as appropriate, protocol would be open for discussion, comments, questions. Hearing none, I'll call the motion. All in favor of executing this agreed order, please say aye.
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 Any opposed, please say nay. Abstentions? Hearing none, I declare the motion approved to execute this order with regard to Mr. Woldendorp. And Jill will get you that signed order. Okay. Next. Randy, I think we've got cases coming up.
You guys are muted.
Sorry. 2023-05-1038-00 LSD, and that is Mr. Blaisdell.
Yes, good morning. This case complaint was for unprofessional conduct pursuant to 1843 RCW and Chapter 19627A WAC. Also is the failure to record a survey under Chapter 5809 RCW and failure to provide a map that meets and is consistent with Chapter 332-130 WAC. The facts in this case is the respondent was or is a registered professional surveyor in active status. The complainant contacted the respondent soon after becoming aware of a survey being conducted. The complainant represents the adjoining landowner and managed by the Department of Natural Resources. The respondent performed a preliminary survey in 2022 for marking a line. At that time, the respondent set markers and referenced other subdivision corners, government corners that they had found over the course of their survey. The complainant in this case could not find where the respondent filed a record of survey under the terms and under the consistent statute of 5809, nor could they find evidence that suggested the respondent marked the line that complies with RCWs and WACs. As part of this investigation, the respondent was contacted by board investigators and responded that the survey was performed strictly at the request of the client, and the client had specifically stated that no survey was needed to be recorded, and that historically the surveys were only used as exhibit maps and titled as such. The client in this case had extensive records, and it's a large company at which they requested only temporary markers be placed as part of managing their property. The respondent was open with investigators and the board case manager to discuss this case upon request. It appeared from the information provided the survey was conducted by the respondent pursuant to 1843. The product, the exhibit map that was provided was in fact titled exhibit map, but was and showed the level of detail that would be easily misconstrued as a an official survey. So even though it was titled an exhibit map, it was a survey, and the results of the survey needed to be complied with statutes and rules by those under Chapter 1843 RCW. The map also, exhibit map was labeled specific items, one being a 1/2-inch rebar with no cap, verified from the RPs being reference points that appeared to be a violation of 5809 RCW, since the markers were set by a land surveyor to mark a reference point on a property or line that were not permanently marked or tagged with the certificate number of the land surveyor setting it. So that is that was a appearance of violation. So multiple interviews over the last number of months were conducted by the board investigators, including the case manager, and there multiple iterations of surveys were discussed in this case, and the respondent, as of late, determined by themselves that this survey should be recorded, and so a preliminary record survey was provided for the review of this case manager. The respondent did produce that, and the case manager found that it was consistent with Chapter 5809 RCW and Chapter 332-130. The respondent in this case has agreed to file the map with the county immediately without further delay, and a copy be provided to this board at its finalization. So with that, my recommendation as case manager to close this case without further action. Are there any questions?
I move to accept the case manager's recommendation. This is Dave.
Let's go ahead and do our parliamentary aspect. We need a motion on this.
Could you not hear me?
State it again, Dave.
I move to accept the case manager's recommendation.
Thank you, sir. I did get a breakup in that signal. We have a second.
I'll
This is
second.
Marjorie, I second it.
I think I actually got Matt on that. Is that correct?
Yeah. Seems to be some kind of delay.
Okay, it's been moved and seconded to accept the recommendation for closure. Comments, questions? To consideration, then I'll call the vote on this. All in favor of accepting case manager's recommendation for closure of 2023-05-1038 00LSV, please say aye.
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 Opposed? Nay.
This case manager abstains.
We have one abstention. Thank you. This motion passes. As a closure, Randy, please advance to the second item.
Next case, 2024-01-0146-00 LSV, and this is Mr. Wengler.
Thank you, Randy. I believe I'm just going to read this. Complaint summary that a survey had been conducted in corners marked without the permission of the estate or person residing there. There was an obvious trespass and some of the stakes were found within the fenced backyard. Facts. On 12/2/2020, the landowner, who was the seller and now deceased, entered into an intent to purchase and sale agreement with deposit with the respondent's client, the purchaser, and the seller. The purchaser agreed to pay all costs associated with combining the purchased property and the existing property that they own. It appears both parties signed the agreement. However, it is not notarized or was proof provided that the deposit was paid to the seller. In November 23, the seller allegedly passes away. I don't have any proof of with the death certificate or anything like that. December 14th, 2023, respondent surveyed the property to be purchased based upon instructions from his clients, the purchaser, and produced a preliminary survey for recording showing a proposed new boundary following a fence where new monuments were set. The dimensions of the north-south lines do not conform with the original agreement, but instead follow a fence about 8 feet east of said line. When the respondent tried to acquire signatures for the forms, which I assume is the deeds, he was informed that the estate of the decedent had filed a lawsuit regarding the property in question and had to wait until it was settled to obtain the signatures. In January 2024, the complaint was filed by the representative of the estate of the decedent. And on May 9th, 2024, the staff investigator spoke to the complainant. The complainant stated the purchaser sued the estate to quiet title. The complainant feels like the respondent did not do his due diligence in notifying the occupants that they would be on the property, nor did he do proper research when drafting the boundary line adjustment. The complainant hired another survey firm to survey the subject property, which was recorded on February 15th, 2024, showing details of the encroachment onto the seller's property, which was the subject of the purchase and sale agreement. In May of 2024, the staff investigators met with the respondent to gather more information. The respondent gave details regarding what he was hired for by the purchaser. He was unsure if there was a current lawsuit and was waiting to see if the boundary line adjustment was going through. Staff reminded the respondent of the RCWs and WAC requirements since he had set monuments, and the survey has since been recorded by the seller surveyor showing their placement. The respondent understood and will speak with his client, the purchaser, about recording a survey. In June of 2024, the respondent recorded a survey showing the line for the original agreement, with the fence and the original monuments being set approximately 8 feet east of the line cited in the purchase and sale agreement. Said survey gives the appearance and contains verbiage indicating that a boundary line adjustment was performed, but the survey does not contain any signatures or reference to any documents necessary to convey the property. In June of 2024, the staff investigator asked the respondent if the boundary line adjustment has been agreed to since the survey was titled Boundary Line Adjustment. The respondent responded as follows. I had sent in a contract to you previously that showed that portion of the property as shown on the survey that he is entitled to get. He is still in the process with the attorneys to settle. I talked to him into reporting this and showing the BLA as it will eventually happen. Also, the attorney wanted to record that way in case it goes in front of a judge to decide. On July 19th, 2024, the case file was sent to the case manager for review. Based on the information provided, it appears that the respondent performed a survey of a proposed boundary line adjustment based upon a signed purchase and sale agreement. He reported the survey showing the placement of the monuments based upon the signed purchase and sale agreement. even though there does not appear to be any conveyance or final court judgments that actually moved the property lines. The survey lacked a narrative explaining the rationale behind the decision regarding the boundaries. In addition, the survey lacked other information required by WAC 332-130. On November 1st, 2024, the respondent was interviewed regarding the lack of narrative in compliance with WAC 332-130. The respondent understood the need for a narrative and decided to revise the survey and add additional information to bring the survey in compliance with 332-130. The respondent volunteered to revise the survey and sent a preliminary copy for review before reporting. On December 17th, 2024, the staff received the revised survey, which was reviewed by both the deputy director and myself. The survey still did not meet the requirements of 332-130. I suggested that the revised survey not be reported and another interview be conducted. On 1/10 of 2025, again, we met with the respondent and discussed the lack of compliance with both RCWs and WACs. The respondent stated he understood the deficiencies and will make the appropriate changes. He volunteered to send an amended record of survey for review within 2 weeks. We received that recorded amended record of survey and sent a copy to board staff. Said survey included a narrative with a statement regarding what he believed the board instructed him to do. On June 24th, 2025, we again met with the respondent to discuss the reported amended survey and why he did not send a preliminary copy before reporting. We also discussed the content of the narrative shown thereon. After further review, I believe the narrative on the reported amended record of survey is minimally adequate to meet the definition of intelligent interpretation for WAC 332-130-02011. Other elements of the survey other elements, were adequate of WAC 332-130 were adequately addressed on the amended record of survey. I found no violations of trespass as alleged by the complainant based on a signed intent and purchase and sale agreement with deposit signed by the decedent. Therefore, I recommend the case be closed with no further action. Any questions?
Thank you. Do we have a motion?
I move to accept the case manager's recommendation. This is Aaron.
You, sir. We have a second.
Second, this is Dave.
Thank you, Mr. Peden. Comments, questions?
Yeah, I just wanted to thank the case manager in this case for reviewing this, being a year and a half old and really complex. Certainly with his time on the board and now as pro tem, I really appreciate his involvement in this. Very thorough. Thank you, Jim.
You're very welcome.
Do we have any comments or questions about the recommendation of closure? Hearing none, I'll call the motion on 2024-01-014600 LSV. It's been moved for recommended for closure by the case manager. All in favor, please say aye.
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 I heard enough voices that was all. Any opposed, say nay. Hearing none. Abstentions? That's probably Mr. Wingler.
Well, I'm not voting on anything, so I'm not abstaining.
Well, thank you for that clarification, sir. The motion succeeds. It's approved. Let's advance to the next action. Randy.
Thank you, Mr. Chair. Next case is 2024-05-1005-00 LSV, and this is Mr. Wengler.
Thank you, Randy. Complaint summary. A board-generated complaint was opened based upon an email received regarding a company and an individual advertising land surveying services. Licensing records were verified. The respondent does not have a professional land surveyor's license. On January 13, 2022, respondent applied to sit for the land surveyor and training exam. The LSAT application was reviewed, and additional documentation was requested on March 15, 2022 to verify experience. No additional documentation was received from a respondent, and the LSAT exam was not approved. Facts. The investigation was conducted. The investigator found no evidence of an actual surveying being performed or filed by the respondent, only advertising on a website and Facebook page. The respondent was served with a cease and desist and notice of violation letter. The respondent took down the company website page and the Facebook page. Since the respondent complied and removed all advertising of performing land surveying services, this case manager's recommending the case be closed with no further action.
Thank you, sir.
I move
Do
that
we have a
we
motion
accept-
on this?
This is Maureen. I move that we accept the case manager's recommendation to close with no further action.
Thank you, Ms. Jackson. Did I hear a second? Mr. Blaisdell? Okay. Comments, questions? Thank you. With no comments or questions, I call the question on 2024-05-1005-00 LSV. All in favor of the motion to accept the case manager's recommendation for closure, please say aye.
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 Thank you. Any opposed, please say nay. And any abstentions? Hearing none, this motion passes. Let's advance to the fourth on our agenda, Mr. Garcia.
Case number 2024-09-2424-00 LSV, Mr. Wengler.
Thank you, Randy. Complaint summary is that the respondent has patently false information on his survey that was skewed to benefit his client. The facts: the respondent is a registered professional land surveyor in the state of Washington. The complaint involves a dispute over the location of an upland parcel and the interpretation and validity of a deed as it relates to the location of a river. It appears that the river has moved significantly in a westward direction from the location originally mapped, meandered by the General Land Office in 1859. The location of riparian boundaries are extremely complex. To understand the basic rules, I've cited the sections from the Manual of Surveying Instruction 2009. I'm not going to recite them here, but it's section 3-160 that talks about what an accretion is, and sections 890 and 881, which talk about what an avulsion is. So the case involves the determining of the boundary of the subject properties abutting a river was fixed by avulsion or moved by accretion, erosion, and reliction. The complaint file includes an opinion of two professional land surveyors stating they believe the river has moved by accretion, erosion, and reliction, causing the boundaries to have moved with the river. One opinion is a peer review of the other's work, but both conclude the river moved by accretion, and so therefore so did the boundaries. The respondent reported two surveys indicating the boundaries are fixed by the original location due to avulsion. The second survey appears to be an amendment of the first, but is not identified as such thereon. Both surveys lack a narrative explaining the rationale behind the decision regarding the boundaries of the river. In addition, the survey lacked other information required by WAC 332-130. On June 24th, 2025, the respondent was interviewed regarding the lack of a narrative in compliance with WAC 332-130. The respondent understood the need for a narrative and decided to revise the survey and add additional information to bring the survey in compliance with WAC 332-130. On July 15th, 2025, the respondent sent in a preliminary revised survey, which included a lengthy narrative explaining the rationale for his boundary determination, along with fixing minor edits he encountered during his review. River boundaries are inherently complex, and it appears that the difference in the surveys is based on differing professional opinions on whether the boundaries moved with accretion or were fixed by avulsion. I have found no evidence that the respondent provided information on his survey that was skewed to benefit his client. I recommend the case be closed with no further action. I also recommend the respondent record the revised survey and send a copy of the recorded survey to the board staff. Excuse me.
Thank you, sir. Do we have a motion in this matter?
Mr. Chair, I move to accept the recommendation of the case manager in this case. This is Aaron.
Yes, sir.
This is Marjorie.
Mr.
I'll
Blake.
second it.
Thank you, Ms. Lund. Comments, questions?
So, Mr. Chair, I again want to thank the case manager in this case for diving into this complex issue. This was not an easy case by any means based on the information provided. So I appreciate the pro tem and his willingness to go to this level of detail. Thank you.
Thank you, Aaron.
Thank you. Any further comments or questions regarding the recommendation for closure? Hearing none, I call the motion. All in favor of approving the case manager's recommendation for closure of 2024-09-2404 2424 00 LSV, please say aye.
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 Opposed, please say nay. And any abstentions? None. This motion passes. Case manager's recommendations accepted for closure. Randy, please advance to the next case manager's report.
Next case, 2024-09-2373-00 ENG. And this is Miss Jackson.
Good morning. So a complaint was filed alleging that the engineer in this case was unresponsive and unreachable when the complainant asked for responses to follow-up comments from the city on the engineer's drawings. The facts: upon receiving the complaint, the owner of the company was notified by board staff. After 2 months, the respondent was contacted and he explained that he had closed his business in 2023. The respondent was counseled that he should reach out to the complainant to provide the necessary services or refund their money. He was also reminded that it is his responsibility to keep his contact information current with the board. Successful remedial counseling was conducted, and I recommend that this be closed with no further action.
Thank you, Ms. Jackson. We have a motion on this matter.
This is Matt. I'll move to accept the case manager's recommendation.
Thank you, Matt.
Second.
Thank you, Dave. Questions, comments? Hearing none. All in favor of approving the motion on 2024-09-237300 case manager recommendation for closure, please say aye.
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 Any opposed, please say nay. Abstentions?
I abstain.
Thank you, ma'am. This motion passes. Mr. Garcia, please advance to the next case manager's recommendation.
Next case 2024-12-2465-00 and this is Mr. Wengler.
Thank you.
Thank you, Randy. Complaint summary is failure to respond to numerous phone calls, emails, and text messages regarding progress on engineering services related to approval of the boundary line adjustment. The facts. The respondent is a registered professional engineer in the state of Washington. Although this complaint has to do with failure to respond by the respondent, additional violations appear to have been made based upon information in the case file. Complaint was received on 12/06/2024. Received a response on March 13th, 2025. On 3/21/2025, the staff received additional exhibits of work product from respondent as requested by the deputy director. On 3/27/2025, we received information in the county of jurisdiction regarding requirements for boundary line adjustments as requested by the deputy director. On 4/3/2025, the deputy director discussed requirements with county personnel. It was explained that their code does not require a record or survey for boundary line adjustments, but the boundary line adjustment process handout strongly suggests that one be done. They also do not require in the code that a PLS, professional land surveyor, prepare a new legal descriptions and exhibit maps that are required for a BLA. On 4/22/2025, the deputy director interviewed the respondent. He was asked to email us the copies of exactly what was submitted to the county. He was also asked to send us a synopsis summary of his credentials and experience that he thinks qualifies him to write legal descriptions and prepare exhibit maps, particularly for BLA. During the interview, he stated that 2 unlicensed persons have submitted thousands of BLAs. On 4/23/2025, the case was sent to the case manager. Based on the response in the case file, the respondent states that he had verbal agreement with the complainant to provide 3 exhibits for a boundary line adjustment application with a county in Washington state. The verbal agreement did not include submission of the application to the county or paying of any county associated fees. The respondent was paid $4,995 for the services. No written contracts appeared to have been executed. The complainant states that the work was for approval of a boundary line adjustment. The county of jurisdiction does not require a professional land surveyor to prepare the application, which includes the preparation of a site plan. However, the county's boundary line adjustment process document provided by the county appears to require a survey for final approval. There is a miscommunication or misunderstanding between the complainant and the respondent regarding the product to be delivered. The complainant appears to be asking for approval of a boundary line adjustment, not just the application. The respondent appears to believe he is only responsible for producing the application to be submitted by the client to the county for preliminary approval. On 5/13/2025, the Deputy Director, Investigations Manager, and myself interviewed the complainant, who indicated he was expecting a complete survey from the respondent. On 5/15/2025, staff requested credentials, field notes, legal descriptions, and exactly what was submitted to the county. On 5/19/2025, the response was received. Although there was a field visit to the property, the respondent claimed no original field survey data was collected and no formal survey was performed. He stated in accordance with WAC 332-130 and 5809, the preparation of field notes or survey maps is only applicable when a licensed surveyor performs field work. No such work occurred. No field notes exist for this project. The respondent noted that the package submitted to the county did not contain a signed or stamped survey, nor did it include any representation of having performed the boundary survey. Exhibit C, an exhibit map of the adjustment, includes a note stating, quote, "This is not a record of survey as defined by RCW 5809-040. This boundary line adjustment does not intend to establish, reestablish, or restore any corner of a boundary," unquote. The respondent did produce an exhibit map and two legal descriptions, none of which were signed and sealed by him in violation of WAC 196-23-020-1 and 2. The legal description produced by the respondent, which was submitted to the county, contained spelling errors, an erroneous second point of beginning, and lacked a call for a radial bearing. If the respondent was under the contract to produce a boundary line adjustment application for approval by the county of jurisdiction, he failed to meet the requirements of the site plan checklist issued by the county as part of the application. A search for the county GIS reveals that there are structures on one of the parcels, which is not shown on the site plan. Other elements such as septic systems and their components, drain fields, wells, topography, easements, and other elements required on the site plan are also not shown. 7/16/2025, an interview was conducted with the respondent. A discussion followed regarding the requirement to seal and sign documents complying with WAC 196-23-020-1 and 2. The respondent was unaware of the requirement. We also discussed the need for more formal agreement with his clients to avoid potential misunderstanding in the scope of services being performed, and the reminder to only perform work within the area of expertise regarding preparing property description. It appears that all paperwork was submitted to and accepted by the county, although it was unknown if the final documents were ever filed to finalize the boundary line adjustment. Because this case appears to be a dispute in the services to be performed, I recommend closing the case with no further action. A copy of WAC 196-23 could be included in the closing order. Thank you.
Thank you, sir. Do I have a motion in this matter?
This is Marjorie. I move we accept the case manager's recommendation.
Thank you, Marjorie. A second?
This is Maureen, now second.
Thank you, Ms. Jackson. Moved and seconded. Any comments, questions, discussion on this matter? Hear none, and call the motion. All in favor of approving case manager's recommendation for closure for 2024 well 1065 OOENG, please say aye.
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 Thank you. Any opposed, say nay. Abstentions? This motion passes, accepting the case manager's recommendation. on 2024-12-106500 ENG. Randy, please introduce the next item.
Next case 2025-02-0602-00 ENG. Ms. Lund.
Complaint summary is an owner of a single-family residence has filed a complaint against a professional engineer for breach of contract and accuses them of fraud. Facts. September 2023, the complainant hired the PE to prepare structural plans for a small remodel of the roof and upper floor of their residence. The complainant signed a contract prepared by the engineering firm for $2,500. The architect preparing the architectural documents used for the fee proposal and contract did not indicate that a stair between the lower and upper floors was to be relocated. This and other walls being removed would require modified structural framing. The direction from the architect was specifically to address the added dormer. When the PE received plans that showed more detail in October of 2023, he noticed changes to the stair and lower floor plan. He offered to do the engineering work as an additional service per the contract. Included in the additional service request was a site visit that would be necessary to confirm existing conditions. The owner refused to consider additional fees and subsequently halted the project. They filed a claim in small claims court in November of 2023 for the return of the $2,500, the fee that had been paid in advance. The judge ruled that the engineer should refund the fees. The complainant states that they have not received the monies, although the PE claims have mailed the check in March or April of 2024. Based on the information provided, the case manager does not find the respondent in violation of RCW and WAC for his performance on the project. The PE states that the documents in preparation for the original work were given to the architect at the time that the project was stopped, and therefore the client had received their deliverables. There appears to be communication misunderstandings that led to the disagreements. Concerning the legal matter and refund, BRPELS is not the authority for enforcing small claims court decisions and leaves that to the proper authorities. The case manager recommends closing this case with no further action.
Thank you, Marjorie. I have a motion on this matter.
This is Matt. I move to accept the case manager's recommendation.
Thank you. A second?
This is Maureen. I'll second.
Thank you, Ms. Jackson. Comments, questions? It's okay. So, all in favor in case manager's recommendation for closure? Please say aye.
Aye.
Thank you. Any in opposition, please say nay. And abstention.
This is Marjorie. I abstain.
Thank you, ma'am. Motion passes. Please, Randy, I believe we have one more.
Last one, 2025-05-1640-00 ENG, and that is for you, Mr. Chair.
Thank you. In 2025-05-1640-00 ENG, the complainant alleged the respondent improperly designed a shear resisting system for a residential property under roughly decade-long construction, and that the respondent failed to meet contracted services. The complainant is owner of a single-family home construction that has been extended over a decade and is not yet habitable. Pending county inspection verifications rely upon internal shear details. Respondent was contracted to prepare assessments of framing, roofing, and internal shear design and installation. The respondent prepared each roughly 5 years ago, pending verification of construction installation activities. When requested to close out and seal products and prepare a certification statement to the county, the respondent noted in the certification that the restraint systems and interfloor restraints were not observable to verify fabrication to design, as all were within finished walls and surfaces, and that shear address was completed with additional nailed plywood sheeting rather than the shear design submitted by the respondent. Multiple communications regarding the objectives of the complainant, as observed by the respondent, were intended to constitute a drive to plan stamp the products by the respondent, having the respondent seal work not completed by himself nor under his supervision. The respondent did deliver a product certification bearing a seal with residual expires box. As noted above, he did file a statement, but stating that he wasn't able to verify, right? But he also used an old version of the seal that were from what was under our board rules, still had our expires box on it, and did so only with signature and no date on the seal or product certification statement. Case manager recommends closure with no further action, provided the respondent is guided in proper use of seal and signature of engineering documents, including guidance in remediating the current seal to standard. Sepinda had as chair a motion.
This is Marjorie. I move that we accept the case manager's report.
Second.
It's been moved and seconded. Comments, questions? Hearing none at this time, I'll call the motion. All in favor of case manager recommendation for closure with no further action on 2025-05-1640 ENG, with the guidance to respondent on seal and signature of engineering documents, please say aye.
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 Any in opposition, please say nay. I will abstain. Any other abstentions? Hearing none, this motion passes. And I believe that's all for these case manager recommendations, Mr. Garcia.
That's correct.
You're correct. Okay. So
Hey, Doug.
what
Hey,
I'd
Doug.
like to do now
Doug?
on our agenda. Yes, sir.
I just, quick comment. Jim carried a heavy load this go around. I agree with Aaron's comments. Very appreciative of his involvement on those cases. They were difficult. So thanks, Jim.
Yeah, thank you, Justin.
You're quite welcome. I enjoy doing it for such a great group.
I would echo that and say I appreciate all of our board and staff support on addressing these matters, and the promptness in general of doing so. I understand that many of the survey cases are arduous in time and detail and communications, and so yes, this is important. We get these to our to our respondents and complainants and get them resolved as fast as we can. Thank you very much. Randy, I'd like, as we return to agenda, I'd like to go on to item 2.2 and then maybe give everyone a 10-minute break. So please, go ahead.
Thank you, Mr. Chair. So as of August 2025, we have 61 cases under open case status, 22 under case manager review, and 16 under administrative review. Any questions or comments?
I do not. Any other members? Questions? So, thank you. So our next up is going to be committee reports. I'll take a 10-minute recess. Everyone refill their coffee and their storage systems, and we'll be back at 10:34.
Thank you.
Re-kick off.
We are all set.
Okay, and we're back on board, the special board meeting of BRPELS on August 7th, and we're going to lead off into our agenda items on committee reports. I have item 3.1, on-site wastewater. Did we have a meeting for on-site wastewater?
Sorry, I have to unmute. Yes, we did.
Thank you.
I am prepared.
You care to report on that such?
I do. The on-site wastewater committee met on July 9th, 2025 at 2 p.m. virtually. Committee members are myself as chair, Roger Parker from DOH, who is a on-site wastewater inspector, Rick Wilkerson, on-site wastewater designer, Bob Suggs, on-site wastewater designer, Robert Goodman, on-site wastewater designer, and Jesse Cox, on-site wastewater inspector. Support staff present was Ken Fuller, Christina Horton, Mackenzie Wirrett, Bryce Dickerson, Shannon Gillespie, and Vonna Kramer. Oh, great. I pull up the, sorry, I pulled up the agenda instead of the report. Okay, here we go. All right, and in addition was Kevin Ballard, Greg Schefferstein, Elizabeth Lagerberg, and we did not have guests. First discussion topic was the on-site exam results. Ms. Kramer discussed the results from the March 2025 on-site wastewater exam. The exam results had already been approved by the exam qualifications committee. So this was just reporting to the on-site committee. Mr. Fuller discussed whether the committee would be able to develop additional on-site exam items by October, and the committee members discussed the best process in order to develop a new exam, an additional exam, what we have. Action item was Mr. Wilkerson and Ms. Kramer to identify the exam domains that need to be worked on and organize which questions the SMEs will develop. The on-site law review updates. Mr. Ballard covered the updated questions on the on-site wastewater law review and presented to the committee the new online CVT formation of the exam that's now on our website. Ms. Lund directed the committee members to review the updated on-site law review for accuracy and to send any changes to the board staff for approval at the August special board meeting. I believe, staff, that we have not seen anything from any committee members. Is that true? That would be Lana. I assume that would receive them.
Actually, Kevin was working on the law review.
Kevin,
I did do my review and sent it.
Okay. And so were there changes that Kevin needed to incorporate from that?
Yes, there were. I incorporated both Ms. Lagerberg's as well as one of the on-site committee members' changes for review today.
Excellent. Okay. Then committee recruitments was discussed, specifically getting more support from Eastern Washington. And this is, it says committee recruitment, but I'm assuming it's SMEs for the exam preparation, as well as any committee members that we can get to help out.
Yeah, that's correct.
An action item, Mr. Wilkerson will communicate with WOSA to find and develop new exam writers. So that was pretty much the whole meeting and the action items, which I described under each part of the meeting minutes. So is there any questions or comments about the on-site wastewater committee report?
Thank you, Ms. Lund. And right now, I know I've only assigned you as a board member on there. I anticipate that when we have a new land surveyor assignee, we may drop them in to help and start staging that up.
Okay, yeah, I have no problem working with the committee. This is my first time being a part of that committee, and you know, I enjoy getting to know that aspect, and it seems like the other committee members are very willing to be active, so really appreciate that.
Thank you. It is important to be involved with our bodies that we govern, right?
Right.
And so those individuals at least have demonstrated a high willingness and help for the discipline. Thank you. Thank you on receipt for the wastewater ad hoc committee. 3.2, the next would be the executive committee, and I guess I have that. The executive committee met yesterday at 8 o'clock, composed of myself, Mr. Harney as vice chair, and Ms. Lund as past chair, including our support staff, Mr. Fuller, Ms. Horton, Ms. Warrett, Mr. Dickinson, Ms. Gillespie, Mr. Schieferstein, Mr. Ballard, financial consultant Ian Shelley, and counsel Ms. Lagerberg, as well as John Warren as a guest. As far as finances, and you'll have this later in the packet as well, Mr. Shelley delivered his report. FY25 is over, but its paperwork's not done, so it'll be finalized on September 5th. He did acknowledge that the fund sweep occurred of $440,000 on the 1st of July, according to the next budget bill. I had asked a couple questions on data analysis and terms. As you look at it, you may find the term cohort, and what's he really describing is the 2-year cycle of license renewals. So he's binning those as cohorts. And he using a term allotment, which I generally construe to be dealing with legislative authorization, and he's just using as budget plans. So the summary of that was that on the finances, we don't have any current concerns on meeting payroll, so to speak, or any other current expenditures. 1843, our chapter 1843 RCW updates. A number of stakeholder meetings were held, and those were discussed and described in the comments. Written and verbally were discussed and provided. I understand one additional comment was received just 2 days ago, and that will be provided, particularly if it's any different. I don't know if it is, Shannon. The next stakeholder meeting's next Wednesday, the 13th at noon, and we'll be open to all for that. Licensing report, all three professions the board regulates were discussed, and improvements in licensing process. The improvements will increase, will be acquired through increased automation, and they should improve customer experience and redundancy, and emphasizes the accountability in doing so. So Mr. Ballard's been working extremely well in those areas and pulling the most out of our data systems. Forms for experience forms and other aspects of the application aren't connected to Polaris, as Mr. Ballard explained. And those forms are uploaded by the licensing specialist when they received. I had asked for some further timing analysis, see if we basically need additional staffing supports, because the workload numbers actually aren't getting smaller. And, in some venues you want to say well, I guess in most venues you want to say we're always growing, and that's what it looks like. But the question is whether we have the staffing, and so we're going to keep an eye on that. In addition, we want to keep, as we mentioned, we want to suggest more lean trained staff, and so whether that's additional personnel on staff or as we bring in more.
What the heck?
I'm sorry. Okay. And we had our strategic planning items, which performance and stakeholder feedback, those are definitely in progress with the 1843 issues and licensure issues, and licensing system software functionality is also in play. We adjourned at less than an hour yesterday. Any comments, questions? Okay. Hearing none, I'd ask to receive the EQ committee report.
Thank you. So the Exam Qualifications Committee met yesterday, August 6th at 9:15 a.m. Virtually via Microsoft Teams with some staff in person. I am the chair of the committee. Dave and Aaron are also committee members and were on the call. We had several support staff: Ken Fuller, Christina Horton, Mackenzie Warrett, Bryce Dickinson, Shannon Gillespie, Vonna Kramer, Jill Short, Randy Garcia, Greg Schieferstein, Elizabeth Lagerbird, Kevin Ballard, and Emily Weston. We also had guests: Matt Rasmussen, Marjorie Lund, and Doug Hendrickson. We had a discussion about applications by committee, comedy, and using the NCEES record only. Mr. Fuller reminded the committee that the staff had been researching the board accepting only NCES records, but staff have discovered that there are discrepancies in how the work experience is verified through NCES experience record. And so the idea was that we would postpone requiring that applicants use the NCES experience record only. We had a discussion about work experience best practices for the application, and Ken introduced a draft document for best practices to be shared with applicants to use as a tool when applying. And so the idea was that this would be a FAQ that would be on the BRPELS website to help applicants understand what the board is looking for as they document their work experience. The committee had offered some edits for the document, specifically asking questions about the supporting documents that was listed. There was some discussion about whether or not it was too detailed or too much information. There was also discussion about a note on this document that talked about exempting military applicants from the requirement to have a professional engineer directly supervise their work experience, which kind of brought up a lot of other discussions about what is actually in rule and law regarding that. So there was an action item that board staff will incorporate the edits and then also look into more the rules and law that are associated with the exemption for military applicants. So we had some good discussion about that and to be followed up. We also had a presentation by Kevin on an FE waiver analysis for military, government, and industry applicants. There was a request for other states to see what other states were doing. So Kevin presented that information that the board had received back. And then there was further discussion that perhaps it should be open to anyone, not just someone who's military or government employee. So there was an action item that staff would work on this a little bit more and then present at our October meeting, our October committee meeting for further discussion. We had a discussion about the updates to the PE application forms. And Vonna presented the part of the application form that talks about work verification for military and government employees once again. So the discussion was that this needs to be looked at with all 4 applications, and the previous discussion of looking into what is actually in rule and in law and making sure that we're consistent throughout. So this also will be followed up with, I believe there's going to be a task force that's going to be looking into the application changes. So we paused on moving that any forward.
I think that's a requested item 4.3 on our agenda. Thank you.
Okay. Shannon reviewed the stakeholder review comments for the RCW, or Chapter 1843 of RCW updates, and we had some discussion about the change that strikes the requirement that somebody be a U.S. citizen to be on the board. So there was discussion of that. We had discussion of the NCES attestation language. Once the RCW is changed to allow us to do decoupling, we recognize that we will have to change what is on the NCES website. for Washington as far as the process. And so previous discussions were that we needed a new attestation to be put on that. And Vonna presented a couple of options that staff had come up with. And so the committee discussed those and had some tweaks to one of those. But then we also had some discussion from Elizabeth that she doesn't feel that it needs to be an attestation, just needs to be a statement of this is the process. So there is an action item for Vonna to follow up with that. But basically, we're just holding this. We're trying to work on this, but we can't move it forward until after the changes to the RCW. And then we had discussion of WAC 196.16 in the PLS licensing requirements. Shannon went through the edits to this section. I think this is the section that we didn't quite finish. Is that correct, Shannon? And so we will be reviewing that again next meeting. So yes, and then we did talk about moving forward with the CR 101 for WAC 196.12, and the committee approved moving forward with that. And I believe that is it. We had several action items. And we went over our time a little bit. So we had quite the long meeting.
Thank you, Ms. Jackson. Do we have any other comments, questions regarding the receipt of the committee report? Being none, I'll ask practice committee, please deliver their committee report.
Thank you, Mr. Chair. Just a quick mic check. You guys can hear me fine.
Gotcha.
Thank you. All right. Apologies to the board and others here that my camera is not playing nicely with WebEx. So no video of me today. You can imagine my face. The practice committee met yesterday, August 6th, in person and virtually at 11:15, in person at the BRPELS office and virtually via Microsoft Teams. Present were the entire committee, myself as chair, Mr. Rasmussen and Ms. Jackson, many support staff also present, Ken, Christina, Mackenzie, Shannon, Jill, Randy, Greg, Vonna, Bryce, Kevin, and Elizabeth Lagerberg. Guests included our chair, Doug Hendrickson, Marjorie Lund, and John Warren. We had 6 discussion topics. I'll go through them briefly here. They're in the report in your packet. First, we discussed a summary of complaints. Mr. Garcia informed the committee about any current open cases. Right now, we have 3 engineering, 2 land surveying, and 2 on-site wastewater cases. There was no additional discussion on those current open cases. Mr. Garcia also walked us through the administrative closure report. He summarized the report, which details 3 engineering, 3 land surveying, and no on-site wastewater cases. There was, excuse me, no additional discussion on that report. Thirdly, Mr. Garcia overviewed the compliance report and non-compliance report. As of July 30th, last month, 4 respondents are being monitored. All are complying. There was no additional discussion on that report. Next on the agenda, we discussed changes to Chapter 1843 RCW. Thank you, Elizabeth. Language. Yeah, Shannon presented the suggested updates to Chapter 1843 RCW and informed our committee of the stakeholder meetings that occurred. We reviewed the comments that were provided to us, and I believe are also in the board's packet. The next stakeholder meeting is going to be August 13th at noon. Elizabeth commented that She has other boards that have made similar updates to their relevant chapters with regard to U.S. citizenship requirements. The board, if it's unaware, will know that the majority of the comments seem to revolve around the deletion of the U.S. citizenship requirement for membership on this board, as well as the changes to the pronouns in Chapter 1843. The next discussion topic was the draft language for WAC 196-09-050. We took a look at that. It's in your packet. It has to do with some changes to the language regarding the brief adjudicative proceeding requirements. There were 2 additions that have been suggested by our executive director and are present in that packet and track changes. As we discussed those, there were some additional changes that committee members noted, as well as Ms. Lagerberg. So we do have an action item there. Those 2 new items are 2E and 2F, and Ms. Lagerberg is going to review the language in those 2 new sections to try to narrow the scope somewhat of when those apply. In addition, I believe Elizabeth also brought up that the current title of WAC 196 does not fully encompass its purview at this point. Specifically, it doesn't include our on-site wastewater profession in its title. It only includes engineers and surveyors. In that regard, we have an action item for Ms. Gillespie to contact the code advisor's office to get that title changed to more accurately reflect our constituents.
And I have some recommendations for her that I haven't got to her yet. So sorry about that, Shannon.
It's all right. I don't even think we've passed 24 hours yet, Elizabeth, so I think you're good.
Fair enough. She sent me an email right away, though, so I feel bad that I didn't respond right away.
Next up and lastly here on our agenda yesterday, we had the licensing reports. We reviewed those and also discussed some possible changes to their format. Ms. Kramer presented the licensing reports for us to review. That format, as you can see in your packet, has been updated somewhat. If you'll recall, at our last board meeting, our current chair, Doug, brought up the fact that the period over which each of the data was presented varied in its length and therefore led to questions about interpretation of the results as they were presented. So that period now reflects an annual period, as you can see. In that regard, the committee discussed, and as our chair of the board was present as a guest in our meeting, conferred with him about, instead of presenting that report at every board meeting, only presenting it at the annual board meeting, since the current period is annual. I'm sorry, Ken, do you have a comment? I missed your hand up earlier.
Yes, there was one additional minor tweak to RCW that Elizabeth was going to provide for us to start to adjust the industrial, military, government direct supervision under PE. And so I think Elizabeth, remember we were talking about that change we could add that in now into 1843.
Oh, yes. Into the 1843 bill. Yeah.
Yeah. A minor tweak just for your notification, board members, that one addition to it to just clean up the actions we have for verification of experience.
Because there's 2 conflicting statements, one in one statute and one in the other. So one is gives the board discretion, and the other one says shall do X. So we want to remove that shall do X, so it goes back to board discretion. I think.
Thank you, Mike.
Sure, you're welcome. I frankly, Ken, I don't recall that as part of our discussions in the practice committee yesterday. Maybe it came out of another committee. But it's up to you guys where you want to capture it in terms of action items, clearly.
I don't remember.
Yeah, they all bleed together probably for you guys.
Yeah, that was discussed.
I would encourage that we discuss that in item 4.1.
Very well.
Okay. Just want to make sure my memory is still on track here. Okay, let's see. Back to the licensing reports. We also discussed a couple other tweaks to the formatting of that report, which I think will help the data presentation a little bit. Vana is going to work on that. Those will include things like perhaps including a different scale for some of the license categories, which are utilized far less than things like the PE and the EIT, so that we can see that data a little bit better, as well as a request from Ms. Jackson to include the month on when the data for the current year is applicable to, so that it's clear that it's only up to and including a certain month. I think that will be, if we present the data only annually at the annual board meeting, that will probably be the month prior to that annual board meeting going forward. We also had a discussion about our ability to understand the current status of all of our licensees insofar as how many of each license type are currently active in our state under our purview. It appeared, based on discussions with staff, that getting that data was not as simple as it may sound. And there certainly sounded like there was no way to generate historic data as to the number of licensees on any particular category on any particular historic date. But it does sound like it's possible to query the system to generate current licensees of any category at a particular time when the system is queried. We discussed as a board that it would be illustrative and helpful for the board and likely staff as well to understand how many current licensees we have and track that on some sort of continuing basis. It was discussed that if a particular date was set once a year, say the end of the month prior to the annual board meeting, that the system could be queried to generate the numbers of all of our license types that could be tracked going forward. And that data would be perhaps informative. So an action item there. Staff are going to want to look into doing that, and if there's no issues with doing so, that data will be presented at the annual board meeting going forward. Practice committee has nothing further, unless there's any questions.
Thank you. Do you have any questions for Mr. Harney? Hearing none, although our agenda currently has highlighted a break at noon, we're ahead of that. I'd like to ask your indulgence and proceed with new business items 4. And we're going to start with the 1843, chapter 1843 RCW considerations. And if we end up with a motion regarding the discussion that began momentarily during the PC report receipt, we'll approach that. So EQC and PC, let's talk about the 1843.
Is the intent of this to go through the stakeholder comments that are on the screen right now?
Yes.
Yes, since this meeting has started, I've received an additional one. in addition to the one received a couple days ago. The gist of her email was she believes we should keep the U.S. citizenship in there, and she doesn't believe that the board should give any credit for a non-engineering degree. Those were her two comments, and I've added them to the comments that are on SharePoint.
And was there another comment, Shannon, that you had received before yesterday that wasn't on the initial?
Right, I believe
as
it's
well?
it's on this one. I believe the one I sent to Mackenzie. It is, it's the very bottom one. I am against decoupling. Nope, you had it, Mackenzie. Sorry. It's the bottom one on that page. Sorry. Go back one more page. Bottom of page 1, beginning of page 2. There. Sorry about that, Mackenzie. Also, we have one stakeholder meeting, as Doug mentioned, next week. And that is also the last day we said we would accept comments for this particular product.
So I believe that up till the your more recent additions, you have each of these comments in our packet. We've had a chance to review them. And in major context, they're the gender, the citizenship, and decoupling questions. Do you have any other major areas of comment? I guess I should point. Shannon, were there other areas of comment particular that
Yeah, I didn't know if you meant
you
board
feel are
members.
of merit?
Just some that didn't agree with the decoupling. That's majority of it was the citizenship.
So Shannon, let me ask you what, how you're gonna deal with these, because I know if this were a WAC, we would summarize the comments and respond to them. I don't know if that's the plan here. It's not required, but you could do that.
We could. Guess we could just group them and make one and send them I was just going to respond to each individual email. Only received about 12, 13, so. Going to work with that.
I understand that we want to respond to individuals, but one of the values on this is also to have a summary for our legislators, for them to understand what the public and the impacted audiences are asking, and our take on them. And so I believe we need that topical area address provided for our legislative actionees.
Okay.
Will that information also include something that informs them about, this was a number of comments we received out of this many licensees? I mean, I don't know if they already know that information, but that would seem to be prudent,
Okay.
If we had 20 responses out of 20,000 licensees or 30,000 licensees, I feel like that's kind of important for them to know.
All right. I'll work with Ken and Greg and Elizabeth, Chris and Kevin and Mackenzie and everyone else to try to get a summary of this done within the next couple of weeks after the next hearing workshop.
Yeah, my concern is in responding to each individual, you may accidentally say different things to different people when what you really want to say is, a cohesive, one consistent message.
That's just a summary of comments and responses. Okay, I can do that.
So in our packet, we have some of the comments and we have the chapter, but you have a very nice summary of why all the changes have been made. And so I think some of the board members have seen that, but not everyone. And I would think that using that as part of your response to the summary, if you can just refer to that document, then we keep that as our reasons, explaining why we're proceeding with decoupling. So people, are concerned about it.
Update that document.
Pardon?
Update that document based on comments.
I can't remember what you call that.
It's
sheet.
the guide.
The guide.
It's the guide. Yeah.
Okay. Yeah, I'll work with staff and we'll get it. You want us to send it to a board member or two? Or
If they, I'm not sure who all has seen it. I've seen it because of the stakeholder meetings. But not sure if that was part of the packet for EQC.
No, it wasn't. Sorry. Forgot about that.
But it might be just good to send it to all the board members so that if people ask us questions, we're all saying the same thing too.
Was that document published somewhere, Marjorie, or it was just used in the stakeholder meetings?
Shannon, yeah.
On the legislation webpage, board's legislation webpage. If you go to the board page and click on law and rules, underneath its legislation, click on that. That's where it should be.
Okay, thank you. So, discussion earlier related to, I'll say Ken and Elizabeth, you described proposed considerations of other 1843 changes.
Yeah, Elizabeth.
I'd like you to introduce them to determine whether or not at this point in discussing 1843, whether a board member wants to make a motion to amend our considerations of 1843 proposed changes.
All right, I'll let Elizabeth speak to it to start with on the two separate spots that we thought there were discrepancy and where the board shall and board may. I think we were going to clean those two pieces up. Shannon, Elizabeth, do you recall exactly where that was at?
I don't recall the discussions. I'm sorry.
43,040 and 050.
So I was on mute and I just asked Doug, are we doing kind of what you had suggested, or did you suggest there be a motion first and then discussion? I didn't understand what your suggestion was.
I think he was saying maybe you or someone describe what the proposed changes were, and then if we wanted to do that, there would be a motion to make those changes. Right, okay. That's what I heard.
Okay. Yes. I should have made a note of where the shall or the may was. I remember the discussion there. Is that it?
I can help. In the shall is in 050, where it says shall contain statements made under oath showing the applicant's education and detailed summary of work, and shall contain verification of the technical work from professional engineers or professional land surveyors. And then I'm looking for the may up above.
Okay, I remember that now.
What we had discussed was we were just going to remove the verification piece.
Yeah.
Or change something there, because the issue was in the one above, there was an option for the board to have discretion on military and federal government employees, which occasionally do not have professional engineers or professional land surveyors supervising work.
Right.
And we wanted to maintain that flexibility to do that.
Yes, that's the one that I was talking about just a few minutes ago. That's the shall and the may?
Right.
So I remember that now. So you're looking at 190, right? Military experience.
Well, there's
Well,
issues in
no.
the too, but there specifically was issues in 1843, and we thought this would be a good time to add that to it since we're going for a legislative change.
Yeah, I'm so sorry that I didn't keep that note. I feel bad now.
So if I may, my recall is that you proposed removing the clause under fees
yes,
dealing
exactly.
with, okay, a little bit further down, Shannon.
That's the one I remember. But there
Okay,
probably was a shall and a may. I don't.
So
but I
under
do remember
fees, it reiterated who's doing a review. And that wasn't a necessary or concomitant part of fees for application.
right.
You go
And so
down
we
to
were
the
just going to
fees,
remove that.
Shannon. Right.
Was
so
that it? There.
Yes, it is. So that the words would otherwise stop at line 3 technical work. First portion of that.
Yeah, I don't think, since it's application registration fees, I think we decided that we just need the paragraph that says registration fee, professional engineers shall be determined by the board, instead of all this preliminary stuff, which really goes back to, I think, the application process.
I believe the proposal you described there would delete in the first paragraph following comma or at comma and shall contain. So it would be from the line 3 comma and delete. Is that correct?
I think it sounds like we could delete the whole first paragraph.
Yeah, I think that's the conclusion we came to at the end, was we really don't need that first paragraph since we already describe it up above. But again, I think that was the final conclusion, but we could do the other and shall contain verification. We could delete that and leave the first part of the sentence.
So that first part is just informative, right? Pretty much.
Yeah, don't you, I'm asking Shannon, don't we already have the application requirements up above? And so here we're kind of just restating them, which is not necessary. That was my thinking.
Yeah, we do. And they're also black.
And I think it's a mistake.
The context then of 1843 changes, discussion and preparation for legislative action. Do I have a motion?
I am not understanding. I need somebody to show what we're talking about. And I don't know who we is. Is that the exam development?
Yeah.
I mean, the exam committee or?
Could I?
Yeah, so
could
I don't see
explain?
how we can make a motion if we can't really understand what it is we're looking for. We're looking at.
Yeah, would you mind, Doug, if I explained this section?
And
So
somebody mark it up for us so that we're all looking at what we're going to vote on.
and maybe this is, well, I was gonna, maybe we should.
Can I make a comment?
Okay. Yes, please. I think Elizabeth, Dave, tell you what, what's your question?
Well, it's a comment. The committees are still working on this. As Maureen reported, the EQC ran out of time and we didn't even get to discuss 1843. So I'm not sure that there's action required today from the board.
No, Dave, it was a whack that we ran out of time on.
And I
Right,
believe the timing.
43. Sorry, Elizabeth.
No,
I
go
thought
ahead.
we didn't even touch on 1843.
Well, the changes in 1843 were decided in June, right?
Right.
And that's why there had been the stakeholder comments and the stakeholder meetings. Marjorie, correct me if I'm wrong, but isn't that the process we went through?
That's correct, because I believe Shannon needs to have it wrapped up by early September to get in front of our legislative representatives to propose.
As such,
So
that's
if
why
there
I
are
want.
minor changes, we can do that without going back to the stakeholders. But let's,
I understand, but what I believe we need to do is decide if we want to propose a change for what this board has approved. So under discussion, Ms. Lagerberg, you were going to summarize.
Yes. And so here's my summary. This paragraph, the first paragraph of this section is redundant and is addressed in the prior, the application requirements are discussed up above. So this is supposed to be about the fees. So the first paragraph is not about the fees. And the problem with this first paragraph, the reason this came up, this review came up, was because it has a statement, it was pointed out that it has a statement that says the verification has to be done by a professional engineer or land surveyor. And the statement up above is it has to be verified by someone that the board has discretion to determine who should be the verifier. And so we have two statements that are not consistent. And the problem with this statement is there are occasions when the board decides that someone else can verify the work besides a professional land surveyor or a professional engineer. And so the board would like, or at least staff would like, the discretion to allow someone else to verify besides a licensed engineer or a licensed land surveyor. So if this paragraph goes away, then all we have is the statement up above under the registration, the application process. And it says the discretion of the board as far as a verifier. And I can re-explain that in a different way if that didn't make sense.
I believe your summary is elimination of this paragraph that doesn't address fees would eliminate the conflict with the identification of qualifications of reviewers. Is that correct?
And I think yes, and I think it's established that the application for registration shall be on forms. I don't think we need to restate that. So I think this paragraph is superfluous and or duplicative, but also creates a conflict. I realize though that it is a fairly significant change. I don't think it's substantive, except for that one piece that creates that conflict because it is repetitive.
In recognition that if we do not do anything with this, we would probably not expect to see this addressed for several years. Do we have a motion in this matter?
I've been reading above, and I don't see language that gives us registration form prescribed by the board. I'm not seeing that. So I think that this section actually is two pieces. It's the application form and registration fees. So I'd be concerned about deleting the entire paragraph. I think, Doug, your assessment was more accurate, and it should end at summary of his or her technical work, period. And then everything past that should be deleted.
Is that then that you suggest a slight edit in the title of the section as well as that editorial redaction?
Well, I just don't, and maybe I'm missing it, but I've scanned this entire RCW looking for the same language or similar language that would give us authority to develop forms as we prescribe, and I don't see it. So
Well, I
hate
think
to,
that, yeah, that goes without saying. You know, in order for an applicant to apply, they have to have a form to do so. So I don't think it needs to be stated, but you know, you can state it.
Thank you, sir. Do you care to pose that in an actionable item?
so I would make a motion that we amend the current proposal for RCW 1843-050 by deleting the part of the first paragraph that starts at the words "and shall contain verification of the technical work." So delete the second half of line 3, and then lines 4, 5, and 6. It's highlighted on the screen now.
And I believe your intent was also to identify that this are application forms and registration fees in the title.
Sure.
I'll second the motion.
It's been moved and seconded that our draft proposals to legislature be amended with the title change in 1843-050 and redaction of the second clause of the first paragraph. Any comments, questions?
Could I add one comment?
Please.
I think by listing, which again, you've already set up above, but by listing statements made under oath, showing the applicant's education and detailed summary of his or her technical work, by listing that out, you kind of set yourself up to also say, and verification. And you already state up above that the requirements are that, and I can't see the above sections, but I think that it's probably better to say application for registration shall be on the forms provided by the board and furnished by the director, and then move on to registration fee and not have all of this other language, because I do think it's covered up above. All of the things you have to show are covered up above.
Matt and Marjorie, would you care to consider amending your motion?
I will amend my motion to change to make the deletion start at the word "shall contain statements made under oath." So really you're deleting everything but the first line and the first word of the second line. I think that's a good amendment. Thanks, Elizabeth.
I'll accept that.
Okay.
Can I ask
comments?
what you were planning to change the title to of this section?
It would say
application form
and then dash registration fees.
Okay.
So just adding the word forms.
Okay, do we have any other comments or questions on this? She's putting it in red line for you.
And I think the comments, if people ask about this, the comments would simply be that this is redundant. It's covered elsewhere.
And
I would
gives
just
the board in whack. Mm-hmm.
Yep.
Thank you. If you highlight those, Shannon, that would be good to make that evident to parties. Bring back the period, if you would.
Perfect.
Thank you. Any other comments, discussion on this proposal? You still have your hand up, Elizabeth?
Oh, sorry. Was there one other thing that, Ken, was there one other thing that we were
We
Can we
may,
just-
we have this motion in front of us, Elizabeth.
Okay, sorry. Yep, you're right.
Hearing no other comments or questions, all in favor of this motion to alter the title of 1843-050 and redact the back clause of this first paragraph? All in favor, please say aye.
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 Any opposed? Any extensions? I think I heard all the voices. That motion passes. Please, Shannon and Ken, as we advance changes through legislature, let's work this in discussion and application for change. Did we have any other items under 1843? As far as change proposals, what I will note in the general discussion is I'd like a minor discussion, and that be have council look at it as well as we do it. Shannon, will you advance to 1843-130? Paragraph 6. So 130 is shouldn't apply to. So maybe we're moving a little bit because of changes in. So it's now 4, right? Because of changes. So in that proposal, the practice of officers or employees of the government. And I'd like to have a discussion then of whether this provision of exemption for, as you said, the military or federal employees would be construed to apply to exempted service as a reviewer and supervisor under experience records for those licensure candidates. I'd like to open the floor for discussion.
Okay, sorry, Doug, say that again. What were we just?
Okay, so this
you
is
want-
the part that says military and
Right.
don't, when they're working on the government projects in their territories, they don't need to be licensed, right? So the question is, would this be construed to apply to their being in supervision?
In order to verify, is that the question?
Yes. If
Yeah,
they're
and can
exempted from licensure, would they be still exempted from licensure in supervision and verification?
I don't think that would be an automatic. It doesn't state that, so I think that would be under the discretion of the board as stated above. But Ken, sorry, I interrupted you.
Yeah, and also in the new item 3 for folks that are coming from Boeing or from Amazon or wherever that are in an engineering role, and they might have their direct supervisors not licensed but fully qualified. And so we do make those exemptions too, but they have to explain themselves. And so from industry and government, we have both of those. And so what your question, Doug, is would we accept a supervisor that's not licensed and realize that they don't necessarily need to be licensed to be practicing engineering work to a quality of professional experience?
But you still may want to have the discretion, like this wouldn't be an automatic, because you may get verifiers that are supervisors but know nothing about engineering plan surveying. So
Right. And so we ask for a very good descriptor from those non-licensed supervisors. Why do they feel they can be in direct supervision of this employee that's using them as their supervisor for experience to grant their license.
Aaron, you had a question?
I do, with regard to item 3. So, I mean, doesn't that, it's not a wholesale statement, right? We're not saying that if you work for the federal government or you're in a firm at which you know, the general business of the corporation, like the industrial, you pointed out, like Microsoft or Boeing, because it goes on to say, provided that the corporation employs at least one person. So yes, I understand about the supervisory role that plays, but I think in this specific RCW, is that what we're talking about here?
I think
I
that
know we're
was
trying to
Doug's
drive,
question.
you're trying to basically connect the two and make sure that it's all consistent, but you know, is that in another section that we're not seeing in our on our screen here?
I guess the question I wanted to ask is, if we're generally requiring a licensee to be subject to supervision and reviews, recommendations from licensees, but we've specifically exempted those supervision in the military and federal government from licensure, does this, in this current 4 markup, provide essentially an exemption from PE licensure if the supervisor is military or federal government?
No, I do not agree, and it's much on the same lines as Matt had yesterday in the committee meeting. The exemption to practice is not the same thing as an exemption of an applicant that needs to have some level of verifier. Now, maybe there is an instance where a candidate has never worked under the responsible charge of an actual licensee within the military framework. Gaining licensure, I don't think that there's any state, maybe Ken, you know of one that would allow that.
So
yeah, I can't think of one.
So in response to, I think, Doug, your question is like a technical legal question, whether this, where it says the practice of officers or employees, so we're talking about the practice while engaged within the state. So that's where you get an exemption for those people to practice. Now, it's a different situation where a person is trying to get licensed, probably leaving, maybe leaving the government work or the military, or, likely they're leaving. So they're going to practice as a licensee. So that's a different person. And the practice, this right here only speaks to the practice. It doesn't speak to acting as a verifier. And I wouldn't say that a verification or providing a verification is considered.
Okay, so no, let me clarify. I wasn't talking about different parties. I was just saying, when we look and say a verifier needs to be a licensee, but then we say you don't have to be a licensee. So the question is the verifier have to be a licensee if they are practicing for the government?
They can practice for the government without being licensed. but that doesn't mean they can verify someone else's practice. So,
So then the balance of the question would be whether board processes allow evaluation of non-licensed verifiers to justify those. Ken, do you
yeah,
believe we're scoped?
I can say that's
Yeah,
the purpose of the change that we just made. So
right.
that
Allows
discretion.
the board discretion. This is very similar to us reviewing a foreign engineer's experience that comes from China, Japan, South Korea, that they may be working under a non-PE, and their work experience, we verify it through that non-PE by basically making sure that they're at a level that is very similar to our PE level here in the US, and whether it's licensed or not. And so we on occasion have to really go back to that verifier and ask for more information that qualifies them to be able to be directly supervising a person that's gaining this experience. So very similar here. We do the same thing. Fortunately, the Navy and Air Force all have PEs, and the Army does not necessarily require PEs. So a lot of times, an Army engineering officer that we've given qualified experience agreed to it. Their practicing officer or supervisor is not licensed, but we request for the verifier to give us their qualifications, and we go through it in a way that makes sense. And that it's not very often, but similar to the foreign applicant.
I'll unmute. That probably resolves and provides the discussion I wanted to address on here to see if we had other things that were already in place. Do we have any other items associated with this verification in 1843 that we need to consider at this time?
Matt, you'd probably be the closest one to. Is there other things that we had concern over?
Not in statute. There's
Okay.
some the wax that need to be cleaned
I
up
agree.
a little bit, but not in statute.
Thank you all for your indulgence.
Thank you, Doug.
I think we can close item 4.1. Why don't we proceed? We've got a forecast noon break. Why don't we proceed with item 4.2? FE waiver analysis discussion.
Yeah, so Maureen spoke of this, I believe, of what Kevin put together. We sent out a request through the MBA forum, and we got 18 responses of boards that already have considered it. 14 of them have a pathway out of the 18, and 4 do not offer any waivers of FE. And so this is the analysis that we put together of what the information we got. The next slide is our recommendation that we've been asked to move forward with this to provide more refinement to this to bring back to the board in October.
I just wanted to add that on the first slide, it has military, government, and industry, but I think you intended this to be just a general option.
Yeah.
Discussion about FE waivers. Yeah, not just.
Thank you, Elizabeth. Yeah. And Kevin, thank you for putting this together. Appreciate it. It's well thought out, and we'll do a little bit of cleanup and come back with a recommendation for you guys to deliberate in October.
Sorry, Mr. Chair, with your indulgence, I have a question for Ken.
Yes, and I assume Ms. Lagerberg's hands back down again.
Yes. Sorry.
Hey, Ken, on this slide, just so I understand correctly, and I know this maybe isn't the presentation you're asking for us to deliberate on, but when it says 10 years of experience with an approved undergraduate degree, is the intent that the approved undergraduate degree is included in that 10 years of experience or in addition to?
No, in addition, it'd be basically 4 years plus 10 or 5 years plus 10. So it'd be after graduate.
Okay. All right. I understand we're not deliberating this now. Thank you.
I think what that highlights is that when you come forward, there's going to be some, a lot of word parsing that we need to be clear upon. So we want clear statements that will be actionable by applicants. Any other questions at this time? We anticipate this back in 2 months.
Right. And it'll be for your discussion, deliberation, and direction. So thank you. Thank you again, Kevin. Yeah.
Also, just to clarify, this would be a new, it will require legislation, as Shannon pointed out. So it would be a new, you're not going to try to present it for this specific bill. So it will be something in the future. Is that correct?
That is correct. This would be what we're planning to do. Is this would be in direction, and we would be opening the doors up for folks that are, have been working for quite a while, but it would require legislative work.
That will end up being next year, right? Is what we're saying.
That is correct. It would not, or whenever the board would like to move forward with it, if the board chooses to move forward with it.
You may be able to, I'm so sorry to bring this up, but you may be able to change the language to say, the FE language to say at the discretion of the board, just at the beginning of 1843-040, so that then you could make it into a WAC issue rather than a CW change. So you could do that now, and then you could decide later whether you want to change the FE WAC. That might be the expeditious way to do it. I think it would be a very minor change in 1843. And I know you don't want to talk about that anymore, but just offering that up.
Mr. Director, do you believe it would be pertinent to advance proposals for revision of 1843 to address generic in this at this time?
I think it would be very good because it'll take us 2 or 3 more years to get this through. I would imagine if we get our next bill passed, then we kind of get put on hold for a while for future bills. So,
Shannon, will you please pull up 1843 provisions regarding FE requirements?
Yeah, and my thoughts.
I will ask if we have a motion from the board.
Do we need to see the actual section before we move?
That's what I asked her to bring up.
Okay.
I only know of the waiver for comedy under that comedy.
But I think you could look at the very first 040 that has all the registration requirements. And you could, that's the sentence right there, a board approved examination on the principles and practices. It would be the above one, a board approved examination on the fundamentals. You could change that to
unless waived.
Maybe unless waived, or maybe waived at the discretion of the board in rule or something simple like that.
I had draft language. I just have to find it.
Is this not it right here? A board approved examination. Oh, you're looking for it someplace else?
We had we stuck the fundamentals language, the waiver language in a section. Kevin or Ken, do you have it
think it-
handy?
Yeah,
think
it's
it was-
1843-100.
But
For
what I'm
regist-
saying is, you could change it here to make, unless
For
waived
out-of-state
or
applicants.
unless waived by the board pursuant to rule, you could add to that sentence right there. Not there, down there, right there. Item I.
Sorry, what do you want me to add? For
So at
this?
the end of that sentence, under the board approved examination, you could add unless unless waived by the board pursuant to rule, or I'm not sure waived is not the right word, but pursuant to rule.
I think Ken was pointing out though that almost exactly that language is already in 1843-100, print 2. The board shall waive the fundamentals examination for applicants who meet the requirements as defined by the board and rule.
That's
But
for
I
out of
think,
state.
yeah, that comes under the out of state. I mean, we could change the name of that section and remove the out of state and just make it the waiver. That would be okay too.
I think
But-
that's cleaner because I'm looking down at, we
Yep.
have to change the surveyor language.
Yep.
And then
Yep,
engineering
okay.
and training, do we change that? And do we change
Great
land surveyors?
point.
Yeah, I like the change in the title way better.
Yeah.
Sorry, I'm making you dizzy.
You were a front man before. Matt, do you care to make a motion?
Okay, let me think about how. So I would move to revise the title of RCW 1843-100 to remove the out-of-state applicants portion and just have it be, would it be registration waiver or just waivers?
Fundamentals exam waiver.
Yeah, fundamentals examination waiver, probably.
Stop. The first portion is not the fundamentals exam issue.
Correct.
Right. But
I think maybe the point would be
Maybe it should
perhaps
just
he's
be-
suggesting the word just waivers.
yeah, waivers.
Or examination waivers.
I think it's a bit more complex than us just changing this, Matt, because it talks about you have to already have passed the NCWS PE exam. And what we're trying to do with the FE waiver is allow folks to move forward to take the PE exam, but maybe we don't have to worry about that because we're going to be decoupled. So it's a bit complicated.
Yeah, it does seem because it has more than just the FE in it.
Yeah, so the board may upon application and payment. So this is how you get licensed if you're out of state. So this, maybe you break apart. I agree. It's more complicated.
Can we just move or copy section, the sentence of section 2?
And it should say waive. I mean,
Or
sorry,
waive
it should
the
say
fundamentals
may.
exam?
It should say may waive the fundamentals because I think the board wants discretion.
I know we argued that word. We argued that word last year. I'm not sure why we changed it, but yeah.
Okay.
I think
Want me to?
It could
I'm
be
gonna
its
withdraw
own.
my
It could be
motion
its
then,
own.
because it sounds like it's more complicated than we thought.
Well, it
Why
could
don't
be.
we
I wonder.
It could be its own It could be its own statute. So just
Okay,
break it
so
off. So sorry.
We're building this during the middle of a motion.
So
We need to decide what we're doing.
motion.
Matt, do you believe your motion addresses the topic? And
No, it's obviously more complicated than just changing the title, so I'm going to retract my motion.
thank you, sir. Do we have any other motion at this time?
As I said, it's the simplest thing would be to break this waiver off and have the registration for out-of-state applicants be one statute and the waiver be a separate statute.
So that would
give
be
you the
105.
If there is not a 105, then
Why don't we
yeah.
could we take this off and we could work on this and maybe we have a special meeting? I think it even can go into if we had October, we could still fulfill this change before Ledge would have it see it. It just the governor wouldn't see it in the BEARS process. We still have time. So if we pulled this out and we discussed it and you guys agree to the potential waiver, we want to change it, I think we would have time in October to edit some of this language before it gets on the floor.
And again,
Thank you, sir. As you do so, I would like you to make sure that we're consistent and coordinated,
Yeah.
and that we don't have another set of essentially parallel constraints like some of the things we've been seeing, right? Coming in from other directions. So let's make sure it's cohesive. And we'll look for that in October, or if you believe the advancement merits it, bring it forward to a special meeting.
Okay. Thank you. Thank you, Shannon. I know that puts a lot of pressure on you too. So, and Elizabeth.
Yeah, Shannon, we can just discuss it, I think, and Ken. It seems like a pretty simple change.
Yeah.
And yeah, so.
Probably bring Matt in it as an advisor to start with. So.
Yeah.
Okay, thank you. I
Mackenzie,
think,
I'm handing it back
we'll
to you.
leave the 4-2 then in the hands, Ken and company. Let's go ahead and I'm gonna briefly, then we've got a 4-3. It came out of EQC. Maureen, did you want to speak to that?
Well, I guess I would ask if Ken wants to. This seems to be something that came up in the EQC that had discussion prior to our meeting as well. But
yeah,
I think the issue is that we've been working on different pieces of the application, but there's a need to make sure that we're consistent across all 4 applications.
Okay. So, I've considered that, and I've asked, and I'm going to ask a applications task force be set up. Maureen, Marjorie, I'd like you to chair that and ask Matt to support you with Vonna, Ken, and Kevin. We'd like to have those coordinated application forms. You've got experience with them, and we want to go ahead and make them consistent and coordinated. I would like to have the task force reply back with drafts by the December meeting, with basically some hold points for proposed changes that we're waiting for Form 1843. Do you understand that charge?
I understand that charge, and I'm happy to lead the charge.
Thank you, ma'am. With that, I'm gonna take a short poll. How long do folks want for their lunch break here? We've got a half hour targeted.
Half hour
You're
works.
speaking, Elizabeth?
No, sorry, I wasn't.
Okay. So not hearing anything else, but knowing where we are and where we're going on some things, let's go ahead, recess till 12:30, and we'll see you back at that time.
Thank you.
Okay.
Yes, and I just resumed the recording, so we are all set to continue.
Thank you very much, Mackenzie. And we were leading into items 4.4 on the PEPLS on-site law review changes. You want Kevin to lead that? Is that correct?
That is correct. Apologies. So a little bit different of a format than what we saw last time. This has been through the committees. It has been reviewed by this specifically on-site committee. All changes from Ms. Lagerberg and the on-site committee are reflected in this document. I am here to field any questions.
I had a question. So, did the committee see the track changes? I don't remember us talking about this in committee. So they could see the actual changes that were made?
I
They
thought
did see,
so.
they did see the changes that were made. This is the final document.
Okay, good. I just want to make sure that they saw the track changes. So, yeah. Thank you.
And then the on-site committee specifically saw your comments, Ms. Lagerberg.
Aaron has his hand up as well.
I was just going to ask, we're talking about on-site. Did we skip over the engineering and the survey law review? I have that in my packet first, and this is the third one.
I have to admit that I just got my reviews of the survey law review done. I got them to them like maybe 2 days before the meeting, so they may not be in the packet, and they certainly haven't been discussed by the EQ committee or whoever's supposed to review it. And also, I haven't had time to do my review of the land surveyor, so I promised to get that done promptly after this.
We looked at them at the last board meeting.
We did, Ms. London. I believe the direction of the board was to have them reviewed by council, and then upon review of council, they would be subject to approval. I think what we're going to ask is that they're approved, and then as an outlier, once they're reviewed by council, the land surveyor law review will be published.
So I have a question on the land surveying law review. Some of the questions are still not correct.
I still haven't reviewed it. I still haven't reviewed it either, so I cannot recommend or
no. I don't recommend we go forward with the survey law review.
Yeah, maybe we just pull back to the on-site. I know, Kevin, you want to get them all in one packet, but the on-site, has it gone through all the review processes?
I don't remember actually discussing it. That was my concern about the on-site.
We discussed it in the committee meeting. It was sent out to the committee to provide comment. I have incorporated those comments into the new examination, and I know that council has looked over it.
I apologize. I think I was at that meeting, so I don't remember, but that's not surprising.
And then the PE and PLS ones, we still need to have council and subject matter experts review it, or have we already had subject matter experts review the two of those?
Subject matter experts has reviewed, council has reviewed the engineering one, but we'll review the PLS one here shortly. So
okay, and board members have reviewed the other two?
Yes, last board meeting, each committee reviewed them. I will state that the PLS one has not been updated, as it is still waiting on council's comments.
Okay.
But once that is in, it will be updated.
I'm so confused because I don't feel like any of my proposed changes have been discussed.
Yeah, maybe we
But
just,
especially the PE, but especially I know you haven't had time to do any discussion of the PE.
okay.
So I know that.
Kevin, let's pull this back. Let's drop it into October. Let's make sure we've communicated it cleanly. And have all have the council reviews, since those are triggers, completed.
Okay.
Yeah,
They
thank
need
you.
to be really early, right? I mean, it isn't the issue that we're getting these packets, you know, in the last week or something, and people don't have time to respond with comments. So
That's why,
we
yes,
yeah,
that's
if
on
we could
me.
get yours, Elizabeth, early, it would be great.
And now you have my on-site, you should have both my on-site changes, which I guess we discussed, but I don't remember. And then the PE changes are done from my perspective. But I don't want my changes to be automatically incorporated. I would rather have I'd rather have the committees like look at them and discuss them and decide if they want to incorporate them or not. All I can do is provide recommendations. I can't tell you guys what to do. So I'm not comfortable unless you've talked about them. And then the LS, I will get done in the next.
Thank you, Elizabeth. We agree, and we'll move forward.
Okay.
He'll get those, make sure he's got concurrence with you on what your comments are, and get them to the board members for consideration for the October approval of advancement. Next up, item 4.5.
This is not ready for board action.
Okay, I think we heard that in comment earlier. When do you believe it's going to be ready and talking to PC? Mike?
Yeah, sorry, Doug. Yeah, this just requires some additional language from Elizabeth. So Elizabeth, I feel like we're stacking up the action items for you, but I think there's some minor tweaks to E and F that need to be incorporated. I imagine that goes back to the PC at our next meeting, and then hopefully ready by next board meeting.
Okay, so you believe the CR 102 advancement would be available in October?
I would think so. I don't think that the revisions we expect from Elizabeth are really at all controversial. I think they were pretty clear. So I don't foresee any issues.
Thank you. Let's take that as an action item for the October meeting. That moves to CR 101 on 19612. Maureen, care to speak to?
Maureen, would you like me to speak to it? Shannon.
I don't think it's in the packet.
There's nothing in the packet.
Shannon, please.
It's a request.
Sorry, I didn't unmute myself. I was over here talking to myself. So go ahead, Shannon.
The EQC is requesting that staff be file a CR 101 to work on WAC 19612. That's registered professional engineers. We'll be looking at the retirement section, the work experience section, and then any other language that we may need to amend.
So that doesn't include any decoupling? Is that not in that section?
No, that is a section. We have some draft decoupling language, but not including it until the legislation.
Okay, so we're not working ahead on things to get ready for when it passes.
We'll do
we have
that.
it on our list, but I think we we ran out of time with the other things we had on the list ahead of it, so.
Okay, so that's not what this one's for. Got it.
So
Do you
thank
need a
you. We have a
motion?
motion to approve the CR 101 to open 19612 for the editorial and other changes proposed that were described by Shannon.
So moved.
That was
I
Ms.
second.
Lund.
Yes.
And okay, it's been moved and seconded. Again, a CR 101 is a general advertisement. It says we're considering changes for. So with that, any further discussion? Hearing none, I'll call the vote on item 4.6, approval of CR 101 for advancement at 19612. Considerations of change. All in favor, please say aye.
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 Opposed? Hearing no nays and no, do I have any abstentions? Hearing none, that motion's passed. Please, Shannon, move forward on the CR 101 as posited for 19612. And the EQC will be continuing to work on the content, correct?
Yes.
Okay. Next up on our items of 4.7, which is NCEES motions. So I committed to and gave my opinion of what things are and interpretations and meanings. I said it as a spreadsheet, was filterable, but that may not be necessary. Potentially, she printed it in a single page, I guess. So this item on our agenda is to discuss the NCEES motions and says and voting instructions. So Ken, do you have particular content that you wish to highlight or diminish?
Sorry, I clicked off mute there. Marjorie and I have been talking about a few of the motions later on, but I don't have any specifics other than the licensing group. Yeah. You're muted.
So licensure 1, 2, 3, I think you're probably questioning.
I have to get to the, see if I can find it in your spreadsheet. So, do you want to talk about that now?
Wish.
So the Committee on Licensure was a new committee approved last year. And their charges are in the summary of the annual meeting summary. And out of the charges that they had for looking at licensure in general, they came up with a list of criteria for professional engineering work experience. This was kind of a starting place for them, and they've said, you know, they want to work on surveying at some point, but they have presented some motions which probably should have sent to whoever is showing. Basically suggesting that there could be what they call a rubrics of professional qualifications that better help define what work experience needs to be documented during each work assignment or job that a person has. And Ken and I had looked at that and said, you know, we like this. It looks good. It looks fairly similar in a lot of ways to the criteria that we've been looking for and that our staff has to go find within the NCWS record. So if it's listed more like this rubrics, it's going to make it easier for us to find, and perhaps we can make some suggestions to them on some of the other things too. I brought that up to Jason Barbie out of Oregon, who is leading the Western Zone Mobility Committee, and asked him if that had been discussed, because this committee is also looking at how does the NCWS record work for our application processes. And that's the first step of the Western Zone saying, how can we make our comedy between our states more seamless? And so he had talked to Jason Gamble, who heads up the exam department, or is the CEO at NCWS, and he responded that the motions and the recommendations from this committee on licensure is not going to be incorporated into the NCWS records. They don't have any plans to change the records. And that the motion is presented mostly for the use of jurisdictions. I don't think that that is described in the motion or in any of the commentary. And I feel that it might be valuable at the annual meeting for that to be presented so that all of the jurisdictions know that that's the intent, that, you know, maybe a tool that various states want to use, but that it's not going to become part of the NCWS record. We had a mobility committee meeting and we talked to Steph Goodnow, who heads up the record review team that looks to see whether people have enough experience in their discipline to be credited certain years of experience. And she also said that it wasn't intended to be used for the record, but that they are looking at some changes that are going to maybe happen to the record, specifically having to do with verifiers and how verifiers are identified and what they respond to. But that they might develop this as an amendment that could go forward. So what I wanted to discuss today was I'm in favor of the motion. However, it doesn't state that it's going to become something as part of the NCWS record, not even instructions to the applicants as to what kind of information they ought to put down. And I think that would be great if that could get discussed at a business meeting at the annual meeting. So does that mean pulling it from the consent agenda, which is where it is now, licensure number 1? The board endorses it and it's on the consent agenda, which is that yes column.
Thank you, Marjorie. So the product that they're asking is that they have a position statement. That sounds like that's a motherhood and apple pie kind of thing. Okay, so
well, they have a whole form that they've developed.
It's part of the appendices.
Yeah. I don't want, I mean, I could send this over, we could look at it, but I'm not sure that we want to take that much time at the board meeting. I think it might be something more that you talk about with other boards when you're there, and whether people want to have that discussion, which is basically, there's some really good work that came out of this committee. And in the charges for the committee, I'm going to just read you one. Ensure that the rubric framework can be integrated into the NCAAS record process for engineering experience reporting and evaluation. The framework will support and enhance the current NCAAS record and will provide for more information for reviewers. That was their charge, part of their charge. And so I assumed that if the motion passed, it would be part of the record, or that they would work to incorporate that in some way. It could even just be instructions to the applicants. So it seems like there should at least be discussion at the annual meeting where NCAAS explains why they won't incorporate that in. Or if this committee on licensure knew that it wasn't going to get incorporated in, there's no description in their report saying why they chose to recommend not incorporating it. So it's specifically in their charge, but it is not addressed in terms of their motion or their
So
explanation.
although you I'll just say the word enjoy the product and believe it's generally a good product, you want to take an adverse position because they haven't followed through.
I don't know that I would be an adverse position. I just want it to be discussed in council. So that's the kind of awkward thing, pulling it from the consent agenda, but saying, look, we're in support of this, but why, let's not approve it and then just have it be a checklist that's sitting somewhere in the cloud for people to pull down. I mean, why not have the conversation about why isn't this part of the record system? And this goes on to be an issue with how we're looking at our applications and revising our applications and how much we want to allow the NCAAS records to be used within our application process. If they can't look at these professional qualifications, which Ken has also pointed out to me that it really meets what the model laws require for professional engineers. So why isn't it part of the process that their records reviewers are looking for? And we are having cases where it appears that the record reviewers are allowing some experience, which is not actual engineering experience, to qualify. And then they come to us and we say, well, that's construction, not engineering. And then it creates a real awkwardness. So as part of my looking at the applications, I may be saying, look, I don't want to accept the work part of the NCAAS record if it's going to put it into this position where they're approving years of experience that we can't accept as engineering work. So that's where all this goes. But it seems to me, just I'm asking at the annual meeting if you wanted to open it up to make sure that all the other jurisdictions were aware of the fact that, that it doesn't really say in there how this is going to get used. And so I made the assumption it was going into the record, and then we find out it's not.
And Aaron has his hand up.
Yes.
Yeah, so I am not of the belief that the 3 or 4 motions here, there's way more from licensure, 9 of them. I am not of the belief that all of the charges cover, or all of the motions cover all of the charges. I don't feel like you, Marjorie. I don't feel that I'm reading the motion and it specifically points to or addresses the charge or charges in totality. I want to say that the motions are based on the results of the discussion by the committee. I don't believe that the discussion on if we voted for this as being, it's on the consent agenda and it's the board of directors support it, and we say that we agree with licensure motion 1, I don't think that we are really saying that all the discussion and all the charges with regard to motion 1 are we agree with. I'm not. I think that we're saying that motion 1, do we agree with it should be a position statement? I think that that's what we're more or less agreeing or not agreeing, or going to be active on it at the annual meeting.
What happens, what is a position statement then? What does it go into a policy or into?
So the position statement, and this is the second one, I think we have the artificial intelligence position statement, and there's a number of position statements that NCAA has. They're more or less sort of, this is sort of where the overall flavor of the council and the organization is, but it does nowhere hinder or hamstring the member boards to enact or take a position otherwise. It's just, this is sort of, hey, this is kind of what the overall flavor of the council and organization is. With regard to motion 1, that position statement, I don't think that it hamstrings our board or any other member board from taking action or not agreeing with it. I don't think that it doesn't do anything other than just sort of get it out there that, hey, this is sort of the overall flavor of the group.
Yeah, I'm not saying that it's hamstringing us. I'm just saying that it could be used in a way that helps the process as opposed to, hey, this looks good. Let's take a position on this. And
yeah, I mean, it doesn't have to be absolutely, but I think that the position statement or the motion 1 by supporting it doesn't mean that you are in fact supporting all the other charges or things that are within that committee. So the citation that you read, ensuring that the rubric framework can be integrated, I don't feel that, of course, motion 1 affects that. It may be in concept, but I don't think that it limits or affects that rubric. I would say this, though, is that's the reason we're discussing it within the mobility of the Western Zone is, do the motions presented by a licensure committee, do they actually resolve, discuss, or say anything to the charges before them? And the Western Zone needs to discuss this because there's a number of member boards that don't feel that they did. That there's other details like you're pointing out with experience verification, all that stuff, in which I don't think that the licensure task force or the licensure committee really put enough meat and potatoes in their motions to actually do what they were charged to do. At least that's just my opinion. So I personally, I don't feel that the motion one is contrary or so contentious of an issue that we should, as a board, try to pull it off of the consent agenda and engage with the full council, or see what the full council has for an idea. But I mean, we're one board. There could be other boards that feel that same way.
Thank you, Aaron. Any further discussion on licensure one motion? Okay. My own notes said that I don't support their licensure 2 and 3. Because those are basically giving experience as by mentorship, which is contrary to our code. But maybe the question is, do you believe we should work to pull that from the consent agenda since we're not a model rule state?
Yeah, that's always the issue is, oh, well, it's, model rule, it doesn't affect us directly, but I agree with you, Doug. I think mentorship is such a undefined term. Everybody sees it in different ways. And it just makes me uncomfortable kind of having it in there. So whether you choose
our experience records actually say mentorship, it doesn't count.
Yeah, okay.
Okay, that's
So
our in our code.
We could pull it or just wait to see if a model law state pulls it and vote against the motion.
Yeah. I mean,
I'm leaving that to you. I don't know if we need to make a vote yet on who's doing the voting, but
well, yeah,
leave that to you.
I guess for what it's worth, this is the licensure committee wants it to go to UPLG committee to incorporate. We can then pull it from the consent agenda next time if it ends up going on the consent agenda, right? It's like we get a couple bites of the apple here. If we want to pull it from the consent agenda and debate not the experience, but whether the UPLG adequately or effectively puts it within the model rules and model laws, that's what we're ultimately doing with pulling it from the consent agenda and discussing it on the floor this time.
Yeah, it suggests also it's not just the mentorship, but their striking of the experience gained under an unlicensed official. That to me is what they're trying to do is replace that with mentorship. It's not mentorship. What working for Boeing and working, just recently with licensed people or unlicensed supervision, that what they're striking is very important to us because we use that. So why wouldn't other states want to use that?
Right. I completely agree with you. I'm not in favor of it, but I think that the real question is, how is UPLG, who is their mission, their whole point, that committee's point, is to try to incorporate it and where to incorporate it, if any place within model rules and model law, that's their charge. The licensure committee is more or less, hey, this is a great idea. UPLG, you're going to have to figure out if it even works with our current model rules and model laws. So I don't feel that discussing it at this point when the UPLG hasn't even looked at it yet is really a place to debate it. or
Well, I
discuss it.
disagree, and I'm going to respectfully disagree, because what happens is when these things start in a pathway at NCAAS, they don't turn around. Yeah, UPLG may say that the words are not correct, but they're by striking this and changing to mentorship, that's not going to be UPLG's responsibility. They're just going to put it in language that's legal. And so I think we need to, if our board doesn't like this, we need to say no and take it off the consent agenda and say we think it's the wrong direction and stop it before it goes and gets into code, or try to get it developed into code. Because we only have one strike at this, and it's now. When UPLG mentions it, it's already going to be too late. So if somebody, I don't know if the 3 board members that are going, if one of the 3 or our board's position is they want to say no and argue this, I think this is our chance.
So let's step back then to the aspect that at the meeting we'll have one vote. Why don't we ask the board to make a motion on who's going to vote under what conditions? Someone please move.
I move that we give our chair the authority to vote on all motions that come before the council.
Second.
We've got a motion and a second. Discussion.
That's just a general overall, because things will come up and things will change during the process. So that gives you the authority to work with the
I
other two.
understood that to generally provide per conscience in
Right.
board discussions.
And push the button.
Is that a Slim Pickens kind of thing? Write it down. Okay, so we have a motion second. I'm not sure I heard any other discussion. Call the motion. One in favor of the direction that the board authorize the chair to vote conscience and discussion at the NCES meeting. All in favor, say aye.
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 Any nays?
Just a point of order.
I'll take
if
that.
this is on the consent agenda and you guys don't want to agree with it, you need to pull it off the consent agenda first and vote on it
So
individually.
let me say I wanted to make sure we had how we're going to do that.
Yes, I just wanted to get that out first, that we have somebody voting. Now I'd like to make a motion to recommend that you pull this from the consent agenda so that it gets discussed.
A second. And this from the consent
I'm
agenda
sorry,
is motions licensure 2 and 3.
Licensures 2 and 3.
Okay, a second.
Second.
That was Matt.
Yep.
Thank you. Discussion.
So this is Dave. I've got a discussion topic. We've been down this road before. I think there's already provisions in the model law that conflict with ours. And I'm just wondering, our objections, is this issue severe enough that we need to be kind of the thorn on this issue? Like I said, we've been down this road before. We're in the minority on some of these, and then in the end, it doesn't really matter anyway because we're not a model law state. So, is this something that we feel strongly about? Kind of going against the grain?
I think you might find that last column, my notes myself on these items were that I don't support them, but we're not a model law. So the question is whether we should pull up from the consent. Just as Ken stated, the train, if we have the train go down the track, we may not be able to stop it, and then the question is application in the end. Now, I recently had to go through a BAP dealing with an applicant. I would summarize it as like a TikTok challenge. How many licenses can they get in it as quickly as they can? So between December and application and BAP, in less than 5 months, a person had required like 14 licensures, and they stepwise up from the least constraining to get an FE, get a PE exam, and pile on the licenses without what we would call adequate experience, or under supervision of a licensee or any design work. So it was, the question then, if this isn't pulled, if this does go into model rule, we're going to probably see products out of NCEES which declare experience, which we can't credit. So the question is, what are we going to have to do on our end afterwards if the products and records are coming to us in a fashion contrary to our general expectations of
Well,
qualification?
this could happen with comedy from other states as well. And we never know.
Understand.
Oh, it does. It does already. I mean, and this would be just another area where somebody might have gotten licenses saying that their mentors have verified it, and they come to Washington and we say we can't do anything about it, and it just creates some real contentious situations. So you could say maybe all of us states that are not model law states shouldn't vote on model law, but then perhaps we shouldn't be accepting the records at all.
Good point.
Yeah, I mean, if it's going to change so much that there's contentious information that misleads a candidate who thinks, okay, I'm approved by NCEES, I'm going to go to my state and get my license, and then that state says it's not acceptable. I'm not suggesting that we back down from any of that. I'm just saying that puts the applicant and us and NCEES in a bad position. So why not bring that up when it can still be discussed?
So I understand. So Marjorie, if we look at the action that was requested to remove the experience not under a licensee, that would fundamentally make an NCEES record more constraining than our current allowance. Do you read it that way?
Well, I don't even know if these changes would go into the NCEES record. I mean, I'm just because it goes into model rule, will it change how it's presented in the record? I would assume so, but yeah, you're right, Doug, that if everyone had to be PE, because they're only addressing the engineering at this point, then maybe that makes it more stringent.
There's PE and PLS respectively.
Yeah, that's right.
Mhm.
I'm going to go back to that page.
So that aspect is more constraining. So I understand the question then is people will ask us why are you relaxed, right? And we'll get other states that may not recognize comedy or equivalent, right? from us. So is that a risk to our licensees?
Well, I don't know if they've defined mentorship in any of their laws or rules anyways. So, I mean, it can be taken lightly. Right now, the NCWS record is becoming very difficult for us to use for experience. And this is going to make it more difficult if they use this and they go to this direction.
So they seem to be doing two things, right? They seem to be wanting to use mentorship instead of supervision under, and then they are taking out the ability to say some of your work experience is verified when you're working under an unlicensed person. So it's two things, right? One is less restrictive and one is more restrictive, like Doug was saying. I didn't read that at first, but I think that seems to be what it is.
But you just say this unlicensed individual is my mentor.
But the mentor thing says a licensed PE and a licensed PLS.
Okay, you're right. You're right. Yeah.
I didn't read it that way either the first time,
Yeah.
but
As an example, I just denied an application that 4 years as a plumber, a residential plumber, those 4 years of experience were given as engineering experience by NCWS. And then the letter that the applicant put in is that I'm working with two friends that are PEs, and they suggested that my work is basically at a level that could be a PE. Would they end up being his mentor then?
he could make that argument if this link, I would see that. Yes, you're right, Ken, right? Whereas
Yeah,
they're not necessarily supervising his work.
right.
That would align with the way we lay it out, right? And they're not signing and verifying his work. He's just saying these people are my mentors.
But it's
So
still our,
I could.
sorry.
Oh, no,
Sorry,
go
Maureen,
ahead.
thought you were done.
Dave?
Well, it's still at the board's discretion to accept the experience, even if
Right.
it's under a PE supervised. So if it's a mentor relationship and we really like the experience and we're convinced, I mean, whether it's mentorship or supervision, it's still a licensed professional, either a surveyor or an engineer. So Ken, in your example there, you weren't convinced that being a plumber, even though a couple of PEs said, yeah, that's PE work, you weren't convinced. So it's still at our discretion.
Yeah, and I doubled it up. I went to Oregon and California, their MBAs, and asked them. They said, no way would we accept this.
Right.
And so it's very difficult what's happening is it gets further away from us being able to accept NCWS record, and that's the opposite direction I thought we would want to take. Is why don't they make it more difficult with the rubrics of experience and all the things we just talked about, but not lighten this up?
Okay, so I think given the general tenor, I'm going to suggest that it's not right for the board to move NCES to move the licensure 2 and 3. And I'd like to work with Ken to see if we can't move removal from the consent agenda, discuss for the detail for future development.
And so I'm sorry, is that because mentorship is not defined?
Both aspects of those motions are contrary to our current codes. Okay, we actually say in our code, mentorship doesn't apply.
Right.
And the aspect of experience under an unlicensed is something we do consider when properly qualified, right? So, with both those aspects contrary to our current rules and approaches, I would like to recommend that we see about moving that off consent and discuss further in front of the board. Or the council is the right word, right?
And I think, Doug, we have a motion on the table still. I think we need to vote on that, on Marjorie's motion.
Motion was voting authorization.
No, I think I made the second motion to
You
remove those
recommended-
from the consent agenda.
Yes, yeah, 2 and 3.
Do what? Remove from consent?
Move from the consent agenda and vote no.
Okay. Did we have the second? Was that Matt? Do we have a second?
I mean, I'll second it, I guess.
Okay. So do we require further discussion on this?
I think that we need to give reason. So I'm assuming that Ken, you're going to work with whoever to fill out the form or whatever. Yeah.
And they may already be removed off the consent agenda, but I'll find out and yeah.
Yeah.
Okay.
Sweet.
Thank you. And so we got a first, second, and in that case, a vote on that motion. All in favor, say aye.
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 I think I heard the full count of voices. Any nays? Hearing none passed. We will work toward taking licensure 2 and 3 from the consent agenda and bring it before the council for detailed conversation. Thank you. Do we have any other specific areas where folk want to talk to on the NCES motions?
I pretty much agree with your commentary on it, Doug, and really appreciate you putting together this spreadsheet. Helps document it.
Okay. Thank you. As I said, the CPC stuff, I think that's where MBA 1. So I again, the only place we're going to do that is we've got our own audit processes. So I'm not sure that that's going to change anything. And so none of those, I'll be frank, that's as much a business path for NCEES to be the storage for CPC record keeping, as anything else. So I'm not concerned. We do see that I guess we do get some CPC reports during audits. Is that correct?
Doug, which motion are you referring to?
I was looking down at the end. So that's an MBA 1. So it's like 62nd out of 64.
Thanks.
And so, Doug, what was your rationale on not supporting this?
It seemed to be that they made it the lowest possible tier threshold. I don't have the language of that motion in front of me. But I didn't see that we would have a direct impact either. You know, we're not following that, and we're not necessarily accepting CPC audit reports from NCEES. You guys otherwise have a drive to oppose or this in any way?
So I don't know if it's the report itself or what the motion is trying to do. And again, just like licensure ones, is they're recommending this to one of the other committees for them to figure it out. And you're basically kicking the can down the road. But I think in this case, where you're talking about CPC, especially with those who hold licenses in multiple jurisdictions, it's I don't think that this motion is saying that if you accomplish one CPC in one state, you get all the other states across the board. I don't think that it's saying this, but I think what it's saying is that you must meet the requirements of each jurisdiction still. Right? It doesn't absolve you from meeting any of the other jurisdictions.
Oh, okay. So thank you. You highlighted back. My recall on it was basically it said, as long as you meet the tiers for your lowest one for where you're licensed.
Right.
But the question for us is, we still have our standards.
Yeah.
If someone else says we only need 10 CPCs for theirs, do we accept that that's compliance under our code?
If the CPC standard is more rigorous than our standard,
If it's more rigorous, sure, but if it's not,
if
then the
it's
question is why would we accept that?
well, and I don't think that this requires, it just says that the if the CP standard is substantially equivalent to your jurisdiction of residence, then that requirement of that jurisdiction is, if it's substantially equivalent to the CPC standard of NCAAS, then you've sort of met that standard of NCAAS. So it's where you're practicing or where your residence is. If your residence is a lower, what I call it, a lower required CPC state, it doesn't mean that you get all the other states that you're licensed in. You still have to meet those. But if your home state is substantially equivalent to the NCAAS standardization, then you want to try to get all those states to be on the same page. It does not absolve you from each state being consistent with their CPC requirements. That's not what this is doing. Is the way I
Get
read
it again.
Certainly, the way I read it.
Yeah, thank you. Do we have any? Let me recast. Who's there next week? You will be, Aaron. Who else?
I will.
Dave?
Yeah,
Did you
I'll be
pop
there.
up, Maureen? Mike, you will?
Yep.
I will not be.
Thank you, Maureen. And I gather you're not, Marjorie?
No, I'm not going to be there.
Okay. We'll miss you all, the others. I'm actually taking my wife for one time. I think we've covered all the grit of import on this discussion. Do we have anything else anyone would like to bring up on those motions and actions for this board?
Nope, not me.
So Doug, just to kind of recap and put a bow on this, that we are going to only submit to remove 2 items from the consent agenda. Is that correct? I didn't see in your other ones that they really rise to the level of us initiating that from the consent agenda. Am I phrasing that right?
I know we had the discussion on one that said we're not happy with it, licensure one. Did we end up
I'm
with
happy
a
with it.
board vote on that position?
I think it's a good motion, but I want to make sure that, and I guess I didn't stop to think about what a position statement means. And so I don't know whether other boards would be thinking that this is going to get incorporated into the record or not. So that was only saying pull it from the consent agenda just so it has a discussion. But I would vote for it. I think it's
okay.
I think it's good work.
Thank you. I generally had support too. I think needs more detail, but okay. So yes, Aaron, I see 2 items, licensure 2 and 3. If this board would work to remove from consent, and get before the council.
Doug,
Yes, sir.
what about UPLG 2? Seems like that one's been debated before. I'm surprised it's on the consent agenda, but you didn't like it. And this gets into the whole ETAC degrees and so forth. Do you think it will be pulled from the consent, or did you want to discuss it anymore now?
If for discussion purposes, I'm not adverse to pulling it from consent. I believe it's misstructured and misprepared, and it's not ready to go forward. So I'd encourage withdrawal from the consent, but if the board wants, we can push and initiate that.
I guess overall, is it worth pushing this question of especially licensure 2 and 3 over to the MBA's base camp? I'm asking you, Ken, is it worth pushing that to MBA's base camp through the Western Zone to kind of get a flavor, see if anybody else is looking to pull that from the consent, much like this UPLG 2? Is it worth it?
UPLG 4, right?
Or I'm sorry. No, UPLG 2.
2.
Oh, okay.
I don't know.
Comedy conditions. Oh. Okay.
Yeah, I mean, UPLG motion two, they're taking away they're taking away the years from 4 years or more to just a bachelor program. But then it gets, like Dave said, it gets into the discussion on ETAC versus EAC. And of course, things that I really enjoy watching the engineers debate on this. But I think that I'm just asking, is it worth that group to kind of, see what the flavor is and on these? I don't know.
So I will tell you what, I'll move that that I seek removal from consent agenda from UPLG 2 motion for purposes of misconstruction, and ask that the council further discuss or send back for. Do I have a second?
I'll second it. It's Marjorie.
Do we have any further conversation on this item discussion?
Yeah, it goes on to the item 3, basically saying if an engineer ought to get comedy, and gives a bunch of criteria which doesn't match ours, and I don't think that that's appropriate for it to be in there when every state has kind of different criteria.
I think this was actually this motion too. I believe it was discussed at, of course, the Western Zone, but I know that it's been discussed within all of the other zones. Northeast and Southern, about the years. I don't think that it's something that is.
I don't remember that. I remember them talking about the engineering tech degree.
Okay.
Yeah, at least I would say we don't want to support it. It's likely that others will pull it also, but it's up to you, Doug, whether we want to pull it.
Okay. So I did a motion, you seconded. Do we have any other discussion? Again, the aspect is pull it from consent for reconstruction and completion by UPLG. All in favor?
Aye.
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 Opposed? Passes. So UPLG 2, Ken, again, is an item that we want to work toward moving from consent and bring to discussion. Open it back. Do we have any other items of significance on the motions for NCEES next week? Hearing none, I'd like to move forward to item 4.8 on our agenda. I have proposed some dates, and Dave, in concert with your interest of having enough advance notice, propose some dates and locations.
Thank
Do we
you.
have any identified conflicts that we know of that can't be addressed in this duration of time?
No. I just want to be able to plan my snowbirding.
Depends on what you mean by snowbirding.
Going someplace besides here in February.
Yeah, I understand. Well, Tacoma's not far from SeaTac, so you're one step away from tropical, right?
Right.
Yeah, and I have room and board in New Zealand for you in February if you'd like to go there.
Nice. So we seem to be deviating from the third week in February. Was that because of surveyor conference? I can't remember.
I think it was because of a state holiday. Is that correct?
No, it's the surveyors conference is usually at the end of the month.
February, he's talking February.
If I may, for February, we have a meet and greet that we're scheduling. If you remember, quite a few months ago, I sent out a hold on that date. Greg and I and Bryce, we've been working with UW Tacoma, and that's why we've got that date selected.
I knew there was some reason.
Well, I was going to ask why Tacoma, so that explains that too. So
It kind of explains where we are in October as well, this coming October. So, do we have anyone
So is
move
this-
to accept these proposed meeting locations and dates?
And then August in the Tri-Cities.
People apparently want to be warm.
Yeah, we couldn't find someplace hotter.
We could go to Phoenix if you wanted.
Phoenix.
No,
might
that's
be
out of
cooler.
state travel. That's not covered.
And I assume that McKinsey, would you guys like me to book our room for that date?
Yes, please. We loved it there. It was great. We appreciate that.
And can we get the water slide turned on too?
We'll see if we can get one installed for you, Ken.
is the Spokane associated with a meet and greet as well, or is that just for Dave?
To my knowledge,
I think Doug was referring to this October's Pullman meeting.
Right, but
yeah,
this October is WSU, right?
Yeah.
In Pullman. So next October is back to Spokane for Dave. I'm just asking.
it'll be easier for you guys to get to Spokane than it is to get to Tri-Cities.
Oh yeah.
Okay, so I'd like to request a motion to approve these proposed dates, subject to future whatever.
This is Maureen. I'll make the motion.
Okay.
Second.
We have a second on that motion.
Dave
Yeah,
was.
that was me.
I'm sorry, I hadn't heard you. Thank you, Dave. Any further discussion at this time? Hearing none, I'll call the motion. All in favor of these proposed dates and locations for special board and board meetings, please say aye.
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 Opposed, please say nay. The motion's approved.
McKinsey, are you going to send out placeholders for all of those?
I will. I won't do it immediately following this meeting so we can get a little break, but I will. In the next few months, I'll send out those placeholders. Most likely, I won't even say months. I'll say in the next maybe 2 weeks, I'll get that out to you guys.
Okay. Yeah, I'll forget and book other stuff. So
Okay, so now all the fun's over. I'm going to ask Ian, who's joined us, to again review the finance report.
Well, hello, good afternoon. In your packet, you'll see a financial report that covers data through June 2025. Before I dive into the figures, I do want to caveat that June is the final month of the state's biennium, and these figures are subject to change until September 5th. It's the accounting adjusting period, so there may be slight changes to the figures that you see in this report. With that said, June came in with 205,000 of revenues. At the time this data was pulled, there was 152,000 in expenses. That figure, I know for a fact, has changed. Expenses have crept up in June to $176,000 in the month of June. Fund balance at the time these figures were pulled was at 1.916 million. That was about a $50,000 increase from April. And then biennium to date, so July 2023 through June 2025, 2 years worth of revenue came in at 4.365 million, 2 years worth of expenses, 3.988 million. And again, that fund balance was sitting at 1.916 million. Pending any small increases in expenditures like we saw in June. Projected biennium 25 and highlights. This section here, again, I'm just highlighting that there are some areas where we might see change up until September 5th. Revenue should see no further activity, but expenses, I was expecting some additional expenses to trickle in. Some of those are listed there, and most of those have come in by this point. And then the fund balance decreasing slightly in accordance with any last expenses that come in. Finally, we're looking forward, shifting our sight, looking forward to the next biennium. So this July 2025 through June 2027. We've been building our spending plan, our revenue estimates for these next 2 years. You can see that listed here. Revenues, we've been estimating revenues in the next 2 years to be 4.7 to 4.9 million. And that's again compared to these last 2 years at 4.3 million or so. The official figure we've settled on as our initial estimate of revenues is 4.85 million. So kind of at the high end of the 4.7 to 4.9 million. Expenses, we've been estimating at 4.65 million or so. Again, we've finalized our spending plan for the next 2 years, and that figure has increased to just about $5 million on the nose. The legislature did provide BRPELS with 5.018 million in authority to spend, and the agency has planned for all $5 million to spend. Lastly, there was a fund sweep that we've had on our radar, been tracking since last legislative session. The legislature enacted and instated a $440,000 transfer from BRPELS fund to the state's general fund. And that transfer did happen on July 1, 2025. Which took our balance from about the 1.9 million to approximately 1.5 million after the transfer was completed. And that brings us, I think, about current. If there are any questions, I'm happy to address.
I don't hear any other questions at this time. As you've summarized in other reports and other committee meetings, it doesn't appear that we'll have cash flow issues And we'll be not too far down at the end of the next biennium, despite the 440 case weight. Correct?
Correct.
Okay. Does anyone else have any questions? Thank you very much, Ian.
You're very welcome. Thank you.
Hey.
Thank you, Ian.
Ken and Christina, would you care to proceed with agency operations?
Yeah, Chris is going to take the helm here, so
Okay.
you good at this?
Yeah. Just a couple of things to go over. One is that our board staff met with the Oregon board staff last week in person for 3 hours in Vancouver at Clark College, and that was a very nice collaboration. We were able to break out into our line of business groups and share experiences and how the different agencies function and how they work. Obviously, Oregon is decoupled, so we were able to learn quite a bit from them. And it was a success. Both sides can agree to that. We had excellent cupcakes, which was, part of the highlight. And it's something that we'll probably continue to do at least in person every year or two. And in the meantime, we can have virtual meetings and continue to build that collaboration. So that was a really big success. And I want to thank especially Mackenzie and Greg and Bryce for getting that organized and finding the location and all the logistics, and for Kevin for really initiating that contact with that staff in the process of doing the lean improvements in licensing. So more to come on that as we continue to build those relationships. Any
Christina,
questions
in
on
that regard, we have that October meeting over in Pullman.
Mm-hmm.
You may find that it would be worthwhile to reach out some to the Idaho board.
Yeah, we've thought about that. The Idaho, we would love to. The Idaho board is in a little bit of I don't want to say a flux, but they're going through some stuff right now. So we'll reach out when it's a little bit more appropriate. Yeah, but yes,
Thank you very much.
we would like to continue that with other groups as we can. Let's see. Ken and I and the team continue to work on culture building, our culture building initiative. Nancy from Open Gate Consulting is helping us work through challenges with that. But Ken and I and the group are dedicated to the long haul, keeping this going and keeping the momentum up. And, we're reassessing as needed and staying curious and encouraging staff. So, it's, if any of you have had to build culture from scratch, it's not an easy thing. But so we're continuing to work on that, and we have another in-person culture building with the group with our consultant Nancy in September. So we'll be able to report out about that at the October meeting. I would like to take a moment and invite any of our guests to go to our website. Under the customer service portal, there's a feedback section there now, and you can click on the option for board and committee meeting, and we would love to hear your feedback on the meeting, and not just the content and organization, but the video, the audio, and we would like to hear from guests when they attend. So any of the guests that are on today, we'd like to invite you to leave us that feedback. And if you have questions about where to find that link, just reach out and we're happy to direct you to that. Any questions so far? Nope.
Thank you. No.
Okay. That's pretty much it.
So, sorry, I do have a question, Chris, on getting back to the collaboration with Oregon, and your discussion. You said that since they're decoupled, is that what the discussion is centering around? Is how they went through the process, how we're embarking on it?
Well, I know Vonna was the only person from our licensing team that was able to attend. Neem was gallivanting around Europe and Emily was unwell. But Vonna was able to sit at a table with their licensing group and ask questions like, how was it for you when you decoupled? What can we sort of look forward to? You know, getting an idea of what that looks like. Some of the process improvements we just made are now we're very similar to Oregon in how each of the staff members work through a certain portion of the alphabet, last names and UBI numbers, and you know, seeing how they do everything. That's how we initially started talking to them, was asking them, you know, those questions. Kevin and I met with their licensing group, and out of that came this, hey, it would be great if all the different lines of business, we could all get together and pick each other's brains and see, you know, maybe there's things we do that they're like, oh, that would be great, and vice versa.
So it wasn't decoupling specific, it was just overall. Okay,
Yeah.
sweet, nice.
Yeah, it was good.
Nice.
Thank you. It's kind of open-ended. We have other items. Do we have any detail on that, Ken or Mackenzie?
Well, we were going to talk about the Learjet, but McKinsey didn't write the check for that one. So no, I don't think there are other items.
You're stuck on Lear, not maybe a Gulfstream, or you're not
Yeah.
open to consideration for others?
No, they're not on
Okay.
the state. They're not on state contract. So
I see. Okay, I don't believe we have any other items under 5.3 at this point. So our next item would be 6.1 is additional public comment. We do have one identified visitor at this point, Mr. Lyman Grover. If you wish to make a comment, our meeting is open to the public, and we invite comments and discussion from the general public. If you wish to give verbal comments, you'll have 3 minutes, and you can comment on any matter that's on the agenda or any matter that concerns you. I don't anticipate this is an issue for you, but not an adjudicative proceeding or hearing. Mr. Lyman Grover, if you have comment, we'd welcome it.
No, thank you for having me as a guest. I have no comment at this time.
You can probably follow up with Christina's assessment of our our meeting through our website, and say whether or not we did a good job for you. Thank you. Thank you for being here. Greg, item 6.2.
Hello. Caught me a little off guard. There we go. Okay, so upcoming outreach and events. Of course, some of you headed to New Orleans here in a couple of weeks. In October, very busy. We've got the ASCE convention in Seattle, finalizing folks that are headed to that. Of course, our board meeting in Pullman, which I did want to take a moment to talk about that. That is the 14th, 15th, 16th, first day being travel. We've got two guest lectures with Mike Harney, one in the morning, one in the afternoon, speaking to students about licensing and ethics. And encourage any of you to please sit in on those. Very interesting, very engaging. It is interesting to watch and listen to the engagement with the students. Of course, we do also have that meet and greet, which is on Wednesday, the 15th. It is from 5 to 6. And would ask if you would please be there by about 4:45. Please also remember to wear your name badge. And a reminder that we are the hosts. The guests are the students, other PEs from that area, and faculty. Some students especially might be a little hesitant to engage us, but would really enjoy and benefit from our conversations if we're proactive and we're able to engage them first. So I would ask please to just introduce yourself, say hello, ask a few questions and see where that conversation takes you. Please also try to circulate about every 10 minutes or so, just so we spread you all around the room and talk to as many people as possible. The other thing I wanted to mention, since I have you here, is I did send out a video and picture guide a few weeks ago. If you don't remember getting that or you'd like me to send it again, please let me know and I'd be happy to resend that. You already look great on camera and take good pictures, but we want you to look good. We want us to look good. And I was asked to do that a while back. And so that should be in your email. If you don't find it, just let me know. Continuing on with our schedule, in October, we do have a ASCE Younger Member Forum happening on the 22nd of October. Dave is speaking to that group in the evening, being hosted by Seattle U. So a blend of newer PEs and some EITs and those that are just getting their feet wet. In November, a similar type event happening at St. Martin's on the 19th of November, ASCE Tacoma Younger Member Forum. Ken planning to speak to that group. That's an evening meeting as well. And then in December, we have agreed to speak to SAME in DuPont. And we haven't finalized that one much yet, but we do have it on the calendar and we'll be talking more about that one as we go forward. So happy to entertain any questions.
Very nicely done, Greg.
Okay. Well,
Thank you, Greg. Would you send me another copy? I probably lost the one
That's
for your
okay.
video guide.
You know, I have a copy I'll send you. So yes, I'd be happy to do that. Anybody else at this time, or just shoot me an email. So.
Hey, so Greg, one question is,
Yes.
I believe, or correct me if I'm wrong, but wasn't the fall APWA we went to that one last year?
We
Or
did.
was it the spring?
Yeah, that's a great question. I'm glad that you asked it because we've gone to, I believe, 3 now in a row. And one of the things we noticed at the last one is we're seeing a lot of the same people. And we were really pushing monument preservation was a big part of that. Plus also just getting out there and talking to people. I think we'd really saturated the audience. And so we decided we'll take one off and may pick the next one up they do it in the fall and the spring. So we may do one in the spring, but we decided to pause it, put our efforts elsewhere this time, but we'll certainly be back at some APWAs in the near future. So thanks for asking.
Yeah.
Thanks all. Appreciate your time.
So we have next, it would be the board and affiliate. I guess we should ask did we have any other inputs from board members on these outreach and events? We have forms and interests and structures with Greg. Do we have any more beyond these that he's identified?
Sorry, sir, was that a question for me specifically or?
No, it's a question for the board members.
Okay.
Basically tell them to work with you to get it on the calendar. Okay.
Thank you. I appreciate the promotion.
So in advance notice, I'll be driving probably through Tri-Cities on the 18th, and I'll be in Spokane on the 19th of September, most likely, because I'll probably proctor those exams. But if I do come through, Matt and Doug and Dave going to be coming right through your territory, so maybe we can catch up.
I don't appear to have a conflict.
That's the 18th of September, Kate, or Ken, or the?
Yes, sir.
Okay.
Yeah.
Yeah. I mean, I got stuff going on during the day, but I'm not out of town.
Yeah. Okay.
One thing that I will throw out to the group is as soon as the annual meeting gets over, we'll probably have a few members going to various committee meetings coming up this fall. So just know that they may get put on this calendar before the next meeting in October. You may start to see them. I don't know what specific committees that we'll have members on, but just know that there'll be some committees assigned.
Thank you.
Good point.
Yeah, we anticipate the NCEES to have committee assignments coming out soon, if you haven't already heard. Okay, so that falls right into kind of 6.3 board and staff affiliate involvement. Do we have anything jumping up?
So I'll start with regard to NCWS. Obviously, going through the motions is one piece of the coming into the annual meeting. So I appreciate everyone having the ability to look through those motions. It's huge to have these out and discussed earlier rather than last minute. Nobody wants to discuss these motions when we're trying to vote on them. And so trying to get in front of it. One of the things that I've tried to do with the Western Zone agenda is put on their agenda the some of the aspects of the motions, but also things that we've been discussing. Decoupling is going to be on the zone business meeting agenda. We've discussed that at Western Zone meeting in Albuquerque. And so that's certainly going to be an issue. Also, what's going to be an issue, just given the group an advanced kind of notice, is the sort of the UK MRA sort of status from a couple people who have recently submitted, and how that kind of their stories or kind of what they saw. So that should be interesting to hear from those individuals. Something else that's coming up in the plenary session, and for those that are going, you're going to get the ability to get into the weeds on a lot of different topics. And so one of those is the structural exam topic that's been discussed with our board and, of course, Western Zone, other zones, and nationally. That is certainly going to be discussed at that point in time. There is a structural, what do they call it? Help me out here. It's like a structural caucus.
Forum or caucus, sure.
Yeah, caucus that is going to be on the first day. There was a meeting today. Let's see here. I was going to let everybody know. I got sort of a little bit of information. So it was a structural exam specification meeting. And so They met today. Some of the issues that were being addressed were on the exam specification. Discussion, of course, not a decision, but discussion was, of course, the 1 hour length or 1 hour longer in exam, and then fewer items. The pretest items went down to 8. That discussion was had at that specification meeting. I'm not so sure. Marjorie, were you or Chun?
So it was the PAC study was was reviewed by the EPE. So the PE structural exam PAC study was reviewed recently by the EPE, and today they had the final meeting to vote and have any last discussion on it.
Okay.
And I had questions earlier that were answered by the exam development committee. I chose not to be in that meeting because I'm here, but also because since I was on all the cut scores and the PAC study, I had to abstain from voting anyway. So, but I'm positive they've approved it. There was no other discussion except mine. So.
Right. Yeah. It says it was approved unanimously. Is what I got from the group, kind of advanced from the group. So anyway, so we have that. It's going to be on discussion within the annual meeting. Looking forward, next springtime is the Western Zone meeting, and that will be down in Bend, Oregon. And so prepare everyone for in May. I am looking at my schedule, and it looks like May 30th and 31st and 1st. No, excuse me. I misspoke there. April 30th through May 2nd is the Western Zone meeting in Bend, Oregon. So just to kind of put it on everybody's advanced placeholder list. So
glad you got the right month, because otherwise I'd be a little further south.
Right. So other than that, Survey Forum is going to be discussing the PLSS exam that's going to be coming online in 2027. And so that's something that as I transition off, it's going to be something that I'm going to be continuing to engage with board members of this group to ensure that we have that at the ready when that's going to be something that we're going to be discussing to have that integrated, hopefully, and then that will affect the state exam, or it should affect the state exam, and so looking forward to that. Other than that, that's all the items that I know about currently today.
You're muted, Doug.
So thank you. I anticipate I'll be working with NCES EPP, unless I forced the hand too much of the chair last year. And the NSPE COPA and the NSPE Western Zone and House of Delegates. I'm not at the NSPE national meeting, which started yesterday in Kansas City. So we're making sure we're staying connected with our constituencies. Do we have other organizational interactions we'd like to highlight?
Doug, if I may,
Yes, ma'am.
I'm going to turn off my video and I apologize for that, but when I turn it on, my connection becomes unstable. So I continue to attend the Department of Natural Resources Survey Advisory Board meetings, which are about 4 times a year. And they're doing some good work there. They've produced a reference checklist of the RCWs and WACs for surveyors and survey technicians, draftsmen, et cetera, to be used. And I did send a copy of that out to the survey board members and pro tem board members. I think that checklist will be helpful in case management and in letters of education, remedial counseling, and that sort of thing. The other thing that the Survey Advisory Board is doing is going back through, they have these Did You Know articles on their website, and going through and updating those and adding some additional, and those too are a good reference or resource for us. And I tend to send those out quite often when people have questions or when I'm doing remedial counseling.
Thank you. Those
So,
do sound like good tools.
Yep.
Do we have provision under our website to say, here's some valuable information for licensees?
I don't know why
Yeah.
not. Yeah. Greg says yes.
I think it would be good to be kind of mutually supportive and beneficial to help ensure our licensees are practicing to the best of their ability and information, and give them that information. That would be great. Thank you.
Mhm.
Do we have other amendments into this section of discussion? Not, Mackenzie, do you have the action items from this meeting?
Yes, I do. If you are all ready. The first action item I captured was Mr. Hendrickson to sign the board order for case number 2024-08-1939-00 LSV, and board staff to send out to the respondent. Number 2, amend current legislative proposal for 1843-050 by deleting the end of the first paragraph and changing the title, or excuse me, and change of title to application forms registration fees. Number 3, I captured filing of the CR 101 for WAC 19612. Number 4, board chair Doug Hendrickson to vote at the NCEES annual meeting on behalf of the full board, Washington board. Number 5, Mr. Fuller as MBA to inform NCEES that we'd like to pull licensure 2 and 3 from the consent agenda and vote no at the NCEES annual meeting. Number 6, Mr. Fuller as MBA to inform NCEES that we'll pull UPLG 2 from the consent agenda for purpose of reconstruction and completion by UPLG. And lastly, board staff to schedule the board meetings for 2026 and send out those placeholders as discussed during the meeting today. Were there any that I did not capture?
I think you've got ours. I think the first one you mentioned is partway done.
It is. Thank you.
Okay. We have any others recall the other actions that we committed to in this? Hearing none, let's look to what our agenda items are for next meeting that we're prepared to identify.
So I captured the FE waiver just as that, FE waiver. NCEES annual meeting report out. And approval of draft language and filing of a CR 102 for WAC 19609. Now I feel like I missed some. Anybody have any more for me?
We talked about the law reviews. Maybe it's an
Yes,
action item also.
Oh, thank you.
Yes.
And then
Also, did I hear you mention the FE waiver on 1843?
Yes.
You did get that, okay.
And the task force was not a report next meeting, but for December.
that's what you directed us.
Yes.
I just wanted to clarify too that the two things that I have to do that I know of with, so the FE waiver and the law review, those are both like action items to me, I think, rather than agenda items. I don't know. Maybe you had it that
They
way.
are action items out of this meeting for agenda direct address next meeting.
Okay.
But I will also, Elizabeth, I'll also include that in the action items list that I'll send to you.
Thank you.
Did we have on there the WAC 19609 revisions that we expect?
Mentioned the CR 102. Yeah. Yes.
Okay. Is that one? Okay.
There is no action item for 109. Elizabeth is still reviewing the language.
I have it for an agenda item. I guess that's hoping that we'll have that review done by October.
Right.
Can you include that as an action item, please, and with my name on it?
Yes.
So council, please do that review. Yes.
Does that go back to the PC or is it going to go right to the full board?
See,
I think it should go back to the PC, and if the PC is prepared to bring that to the board next meeting, then yes.
Thank you.
Anyone else identify any missing action items or agenda items? Hearing none, I'm going to give you 38 minutes back. Thank you heartily for all your support getting this meeting done today, and I'll move to adjourn.
Have a good trip to New Orleans.
Is anybody going to second that?
Yeah, we got motion.
I don't think. Fine. I should personally, it should be a good trip. My wife's going to be able to join me.